Hear ye, hear ye.
I always wanted to serve on a jury.
I'm really super excited to be here, so I really appreciate you having me. I'm looking forward to it.
Creating this whole trial, Daddy.
I want to give a big shout out to the 13th Juror Podcast and Brandy.
Yeah, I applaud you guys. Keep doing what you're doing.
That every time you run into Phil Barber, you should reach for it.
Yes.
And then I just looked to the jury, and it's sort of like, look.
I was in the eye of the storm, and you guys were watching the storm.
Hey, if your porter works, come pop in and say, hey, want some coffee?
You are a ray of sunshine, and I love what you've done with your YouTube channel.
Good morning. Good morning. Good morning. Is my screen flipped? Is my screen flipped today? Good morning. Hello, my people. Hello. Hello. Get your biscuits. Grab your biscuits. Hello. Good morning. I'm inverted. Oh my gosh. I'm inverted. Hold on. How do I uninvert myself? Let me ask Lally. Let me stop. Let me not get sassy first thing in the morning. Settings. I'm inverted. General. How do you do it? I don't know how to mess with my audio. I mean my video. Camera. Mirror. Ah. There we go. Look at me. Uninverted now. I'm uninverted now. Good morning. Good morning. Oh, I just realized I still have messy vacation hair. Let's get this out of the way. Good morning. I will tell y'all, I am very excited to see y'all. However, I was not that excited about leaving my vacation to come listen to Brennan. I'm gonna be honest about this. I did not want to leave the keys to come listen to Lally, but I'm here. Not Lally, Brennan, much worse. But I'm here. I'm here, and we're going to do it. We're going to do this thing. We're going to suffer through this together. We're going to see how it goes. I have read through some of all of the motions, but honestly, y'all know how it is during trial time, because my hair is still falling. Because during trial time, I have streaming all day and then working on podcast stuff all night. So I don't get, there's like no such thing as free time during the trial. So Chat Daddy and I took like a vacation. It's his birthday, so we took a vacation to celebrate his birthday, and it's kind of like my last little like woosah before the trial starts. And so we were celebrating, and I did not read most of the motions. I did read some of them last night when we got home, when I was laying in bed, and but most of them I have not read. So I know that I kind of know the gist of what they are just by the title of them, because I was adding them to my document stuff, but I have not actually read most of them. So I am actually excited to go through some of this with y'all today, because I haven't already pre-read their arguments on this. So we will be hearing a lot of their arguments on this together for the first time. So that's number one. Number two is I I have not, because I know everybody's going to be asking me because my inbox has been blowing up. I have not yet watched the Body in the Snow thing that came on last night. I have not watched that yet. They interviewed me for it. They interviewed a few of us for it, and then they cut all of our interviews. I've heard, like I said, I haven't seen it. I've heard that the majority of us who got cut are like, a lot of the people that they kept were very pro prosecution, and I guess a lot of the people that they cut were either, going towards innocence or at least not guilty, reasonable doubt. And so I've heard that pretty much all of us that got cut were on that side of it. So I don't know. I haven't watched. So y'all tell me if you've seen it. Put it in chat if you've seen it. I'm curious to see what everybody has seen and what everybody has thought about it, because I have not seen any of it yet. I was enjoying my vacation. Much needed vacation. Denise, hello. Almost 2 years. Remember, for 22 whole months. Almost 2 years, just toddling along. Love you, baby. Love you too. I love you too. Happy membership. Regina Crawford, hello. Regina Crawford, gifted a membership. Thank you so much. Thank you, Regina. I appreciate that. And Kimber's Ohio member for 19 whole months. Good to see you. It is good to see you too. It is good to see you too. Oh, Brady, love your shirt. I need that. Let me tell you. So I got this. They had, when we were in the Keys this weekend, they had this like market thing or whatever. And the girl who I bought this from, she has her own small business. It's Cocky brand. Let me find her. She was so funny. And I saw this and I was like, you know what? That's perfect to wear for here. I'm going to put her link in here. I told her I would link it. I was like, yeah, I'm going to wear it on my live on Monday because it's going to be perfect for what I'm doing. And I was like, I will link it. So I'm going to pin it up here. So if y'all see anything you like, she's got some really funny stuff. We got a hat too that says Cocky AF, and then there was there were some cute things. She had some really funny stuff. So yeah, but this is hers. I told her I would link to her stuff, so that's hers. I thought it was really funny. Gotta love the hater shirts. Miss Beezy, hello. Remember 10 whole months. Good morning, Brandy. Good morning to you. It is good to see you. It is good to see you. It is good to see you. Is the band set up and ready to go? Right over yonder past the high top tables. Yep. Oh, I only watched half, but seen Bound so far. Okay, good. That makes me feel a lot better because I haven't seen it. But I've seen some people that have messaged me about it, so maybe it balanced back out after they watched it. We'll see. Oops, I just hit that wrong button. Okay, let's see. You're right. You are correct about that. It is Tuesday. It is Tuesday. Totally missed that. It feels very Monday. It's like the Mondayest Tuesday ever because I was still on vacation yesterday. What time is court scheduled to start? Any minute now. I have it pulled up over here so that we can watch for them to come on, but it should be starting any minute now. Tori the Seed Lady member for 19 whole months. 19 whole months. Happy memberversary. Also, I saw that, why is this not coming up? Did y'all see the brothel stuff? I guess Yannetti was representing somebody there too. No, that's not it. I'm seeing if it was. They're not live in court yet. I'm just making sure. Candace, hello. That ex-girlfriend makes me want to poke my eyes out. The ex-girlfriend. Wait, the one that they dated when they were like children and she keeps coming back up on everything. Is it that one? I haven't seen it. I'm assuming it's that one. She's the only one who still seems to be clinging onto that. Melanie. Hello, Melanie. Remember for 15 whole months. The gang's back together. 15 whole months. 15 whole months. Lisa Dempsey, hello. I've always been obsessed with your kitchen backsplash. I'm doing a bathroom renovation. Just realized I'm using the same tiles in reverse. More white, less black. Ah, twinning. Twinning. I love my kitchen. I really do. I love my kitchen. Yes, that's how I figured. How did I not know that? To each their own, I guess. I don't know. I feel like, I don't know. I've seen people who latch on to other people's tragedies. Like, let me not speculate. It's not my thing. I don't really understand what, what she's doing, but I mean, why is this not? Here, screen. Oh no, I don't want full screen. Let me put these on. Let me get out of vacation mode and get my life back together. I have this on. Let me know, because I have to adjust my microphone and everything. All that stuff that I have to do it again every time I start over with my life. So if I need to adjust it, let me know. I don't know why this is doing a weird thing. There's Turtle Boy. Aiden Carney. There's Esty. She's so pretty. See if I can do it this way. There we go. That looks better. Oh gosh. Trolls are going to be eating this part up. God forbid they're speaking. Brennan's about to request transcripts of everything they said right now. They laughed. Let's play that clip. Play that clip for the jury. Let's get transcripts of everything they just said. Call the witnesses. Get them to come in and talk about it. Hold on, I have to change something real quick.
If you go on the side, that'll be better, please.
Like over there, is that okay?
Perfect. Thank you.
That's okay. But down here on the end.
For real though.
Welcome to Zoom for Government. Enter your meeting ID.
Very loud.
Your participant, please enter the meeting passcode. You have joined the meeting as an attendee and will be muted throughout the meeting. The host would like you to enter. You are unmuted.
You are unmuted.
You are muted.
Silas Wankins. I got an email from Michael saying what the name said.
I'm trying to eavesdrop.
25.
Okay, I have to turn that. I have to turn that down a little bit because it's really loud for me. But is my volume adjusted okay? Because I know sometimes I can't tell when, especially once I've been recording the podcast and y'all come in, it's not as balanced for y'all as it is for me. So let me know if mine's too loud or if that one's too loud.
Nope, it has to be up. Till we get going, then you can put it on.
Oh. Well, that was rude. Did they put her down on the witness list to keep him out of the courtroom? No, because they did file a motion to let him be, to not have him as part of the sequestration order. I think they put Turtle Boy on the witness list to keep him from being in the courtroom. Hello, Ted. Thanks for sharing this. Next, you need to do the Adelson case. I have thought about it. You know, I did Charlie's, of course, and I was in court for most of Charlie's trial. And I had thought about it, but I have some big stuff coming up, so I've got to see what I can do. I can't see the chats for your banner. The banner goes away anytime I put a chat up. So no worries, you won't miss anything. I think that's part of the new rules. No cameras until the judge is on the bench. Yeah. They have all kinds of new rules. Welcome, Bev's Bishlap. Welcome. It is good to have you here. Have we been through the morning brandy checklist? Did you eat, meds, hydrate? Yes, and I still have, I did. So in the mornings, Chat Daddy puts out a drink for me and some vitamins, and I have still half a bagel right here. So I took my meds, so I am good. I love how y'all take care of me. When are you going to reveal your big secret? Very soon. Very, very soon. I have a few big secrets that are going to be coming within the next week or so. So stay tuned. A few big secrets. Don't forget to hit the like. Thank you, Helena J, because I am terrible at reminding people to do that. I am terrible. He is a good egg. He's a very, very good egg. Good morning. You have to be tired from your worldwide travels. I am. You know, it's funny because it feels like worldwide travels, but we were still in Florida. Because we went to Miami and then to the Keys. So technically we were still in Florida, but it felt worldwide. The Keys don't feel like the rest of Florida. It feels like a whole new world, and I love it. It was beautiful. I am not knocked up. That is not one of the secrets. Definitely not one of the secrets. I have, with chemo and surgeries and stuff, that shop has shut down. So that will never be one of the secrets. I gave you permission to stay in paradise, and I appreciate that. I wish I could have.
All persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court and for the County of Norfolk. Draw near, give your attendance, you shall be heard. I'll take the Commonwealth of Massachusetts. This court is now open. You may be seated.
22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Here we go.
Good morning, Ms. McLaughlin.
Morning, Your Honor. Adam Miley for the Commonwealth.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson for Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Ms. Giannetti. All right, so we have a lot to cover, but what I'm going to start with is a decision on the Commonwealth's motion to exclude employees of ARCCA. So I think I told counsel before that I had reviewed. So first we had full hearing from counsel. I heard from the lawyers. I heard from Mr. Alessi on behalf of the lawyers. I've read the transcripts. I've listened to the sidebar conference and read that transcript. And I've certainly read the pleadings. So based on all the evidence, I conclude that there has not been the candor required of all lawyers has not been demonstrated here. I find that there have been repeated misrepresentations made to the court by defense counsel, and I conclude that they were deliberate concerning the relationship with the ARCCA witnesses. They were made at sidebar, in open court, and in pleadings. And I think the record is pretty clear, and I find that on July 25th, 2024, payment was made to the ARCCA witnesses. Yet on February 26, 2025, in a pleading written by Ms. Little, signed by all three defense counsel, says the Commonwealth's motion to exclude these exculpatory expert witnesses, ARCCA witnesses, who were not hired or paid for by the defense, is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. The next page. Ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARCCA witnesses as ordered by the court. So I find or conclude that that was a material misrepresentation.
This is a big deal.
That it was deliberate. So I find that there is a flagrant violation of the Rule 14 obligations. And before I decide which sanctions are appropriate, I need to see defense counsel and Ms. Reed at sidebar. I'm going to ask that the Commonwealth remain where they are. I'm going to seal this sidebar, but I need to have a colloquy with Ms. Reed before I figure out exactly what I'm going to do here.
So here's the thing. They were hired without any knowledge from the Commonwealth. So if she keeps them out, that's going to be a big deal because that is keeping out exculpatory evidence. So if she doesn't let them, as far as not having the discussion about, during cross-examination about letting all of that stuff come in about payment. Trying to hear. Can't hear anything. Letting it come in at cross-examination is one thing. If she tries to keep them out, that's a huge, huge deal because that's keeping exculpatory evidence from the jury. Because the thing is, it doesn't matter if you think that she's guilty or innocent or not guilty. If you think she did it, if you think she didn't, or if you think there's not enough evidence to show that she didn't, it doesn't matter which of those fields you're on. If you keep exculpatory evidence from the jury, that's a big deal. How is this giving her? She's not having a fair trial. There is no fair trial with this. That has been shown. I can barely hear, but you can't make out anything they're saying. One thing about that, if they exclude ARCCA, that could be a appealable situation if there is a conviction. So we'll see what she says.
All right. So there's no greater constitutional right than the defendant's right to a fair trial, including a fair and impartial jury, the right to present a defense and confront witnesses, and the right to counsel, which includes counsel of her choice. So I've just had a thorough colloquy with Ms. Reed. I believe it was extensive and thorough, and she has expressed to me a strong desire to continue with her lawyers. Ms. Giannetti, is Mr. Jackson lead counsel? I just want to make the record clear. Mr. Jackson, are you lead counsel?
We don't define our roles in such a manner, Your Honor.
Okay, so because Mr. Giannetti is not pro hoc vice counsel, and Mr. Giannetti can try this case if need be by himself. All right. But Ms. Reed does have a strong desire to keep all of her lawyers, notwithstanding the Rule 14 violation and the apparent lack of candor, the findings and rulings I've made. So based on that, I am not going to revoke pro hoc vice licenses. I don't expect to have to address this again. Candor with the court is essential. It's the bedrock obligation of all lawyers who appear in this court and all courts in Massachusetts. A lawyer is only as good as his or her word, and I need to be able to take counsel at their word. So
what about Brennan?
I'm not going to tolerate false statements, any stretching of the truth, no misleading distortions. There's no place for that in the courtroom. And Mr. Jackson, you stated this very eloquently in your closing argument last time. So, Commonwealth, I am denying your motion to exclude the ARCCA witnesses. Those witnesses can testify as long as,
like I said, that would have been appealable.
Their reciprocal discovery obligations. I will allow a full cross-examination, Mr. Brennan, and I will review any proposed curative instructions, limiting instructions, or final jury instructions. So that's my ruling on that. So we'll move on to Mr. Alessi. You didn't have a chance last time on the motion to exclude the testimony of Dr. Wolf. So I'll hear you on that.
Thank you.
Okay, hold on real quick. I know, I see y'all, and I am right there with you. That whole speech, the fact that she's giving that whole speech to Jackson, but not to Brennan, when he has, an attorney is only as good as his word. Look at all the stuff that Brennan has done. I get it. It is very, very one-sided when it comes to this. I get it, and I am right there with you. I agree. He gets to say and do whatever, and then be like, oh, my bad. I was wrong. I lied. Well, he never says I lied. I was wrong. He misrepresents so much, and nothing is said. Nothing is said. Nothing. It's wild. It's wild.
May it please the court. The proposed testimony supported by the Commonwealth of Dr. Wolf should be stricken in its entirety. The subject matter of Dr. Wolf's purported testimony by his own report and the Commonwealth's own motion is that Dr. Wolf will testify, is proposed to testify as to the cause and the manner of death of the decedent. That is the subject matter of the testimony. And as the court is well aware, in order for Dr. Wolf to be able to make testimony with regard to that subject matter, he has to demonstrate, and the Commonwealth has the burden of proof by a preponderance of the evidence, to demonstrate that he's qualified, prong one, and two, that the methodology is reliable, and specifically either that the methodology is commonly accepted in the relevant medical community, or that the proposed testimony can satisfy the 5 non-exhaustive factors of Daubert-Lanigan. The entire motion, papers, and supporting documentation fail to even allege that the methodology is generally accepted in the scientific community. It's not alleged, let alone demonstrated. In terms of his qualifications, it is essentially Hornbook law that to testify about the manner of death, as opposed to causation, is cause of death, you need to be a medical examiner, a forensic pathologist, or both. Conceitedly, Dr. Wolf is not a forensic pathologist and he's not a medical examiner. So I'm going to just put aside for the moment the cause of death. I want to speak specific because he's got to be able to show both, because he's opining about both. So there is no demonstration in the record that is before Your Honor as to how Dr. Wolf is qualified to talk about the manner of death. Dr. Wolf invokes a terminology called mechanism of injury. That's the closest he comes to talking about manner of death. And specifically in his report, which is Exhibit A to our motion, the entirety of his opinion is in that exhibit, NDA 02801. It is a mere 15 lines, 1 paragraph. And the applicable aspects of that paragraph is he says the following: based on the findings of his autopsy, his being the decedent's, it is clear that the mechanism of injury was a fall backwards, resulting in not only the basilar or skull fracture, but also a subarachnoid hemorrhage and contusions consistent with a coupe contra coupe mechanism. mechanism of injury is not at all probative or even relative to cause of death. We're not talking about an injury here. We're talking about the manner of death. And mechanism of injury doesn't satisfy it. But the point first, Your Honor, is he's not qualified because he is a neurologist. His CV makes it very clear he's a neurologist, and his focus of his practice, by his own words, is based upon the precise invocation of radiation to treat incurable cancer. That's what his specialty is. That's what he currently does. So in terms of qualifications to talk about manner of death, he doesn't state the manner word, but he uses mechanism. He doesn't state mechanism of death. He states mechanism of injury, and mechanism of injury is irrelevant. So on qualification prong, Your Honor, it is completely lacking in the record that he is qualified. It's not enough to say you're a neurologist and head of neurology at a certain center. And this is juxtaposed next to the fact that the Commonwealth, the autopsy, which is very clear that those that are qualified, Dr. Stonebridge and Dr. Scorti-Bello. Dr. Stonebridge didn't even venture into the manner of death at all, didn't comment on it. Dr. Scorti-Bello, who is a medical examiner and who is board certified in pathology, she concluded that the manner of death was undetermined. So here you have the juxtaposition of a medical examiner qualified to render opinions in those areas, saying the cause of death is undetermined, and you have an unqualified neurologist not speaking to manner, but speaking to mechanism of injury. So in terms of the paragraph that I was just citing in his findings, it says, based on the findings of his autopsy, it is clear that the mechanism of injury was a fall backwards, resulting not only, et cetera, and then he goes on to say the head injury was clearly inconsistent with any type of mechanism of injury, such as a bat, hammer, or a car hitting him directly. Then what he goes on to further to go beyond his qualifications, he says the frozen ground was enough that when Mr. O'Keefe fell backwards, his injuries were sustained. Where is the support that Mr. O'Keefe fell backwards? A neurologist can't determine that is a manner of death. He provides zero bases, zero, for his conclusion that Mr. O'Keefe fell backwards. Where is that? And it's also not in the autopsy. And with regard to his qualifications to determine whether the ground was frozen, I covered that with regard to Mr. Gilman. You need to be a podologist. You need to know something about soil. He doesn't even begin to state how he concluded the ground was frozen. He wasn't there on the date of the incident. So there's no basis for that, but that is part of his opinion and methodology. And now to leaving his lack of qualifications, where is the citation to any study, any acceptance of how Dr. Wolf has come to his conclusions? There's nothing there. And this, Your Honor, is become a pattern of the Commonwealth where they put forth witnesses and they don't tether the methodology, if you can discern it, to common acceptance or the Dalbert-Lanigan factors. So in terms of both prongs, Dr. Wolf fails because the Commonwealth has not even begun to meet its burden. I would like to also reference what we just received last night, which is an article that was co-authored by Dr. Wolf. And I want to note and this is fractures of the classification and clinical features. This is 35 years old, and it is notable both for what it doesn't say and what it does say. First, what this article doesn't do is it doesn't talk about how one determines what a mechanism of injury is. So I'm even going to assume for the moment the parlance of Dr. Wolf, mechanism of injury. And if Your Honor would look at, please, page 593 of the study. And it's basically a meta-study. They went back and looked at a lot of data and information. But it says under results, second paragraph, the mechanisms of injury were similar for all three fracture types. Motor vehicle and motorcycle accidents were the most common mechanisms, accounting for 47%. And then it goes on and it says 3 patients were victims of falls. But what this article stands for is that those were all known mechanisms of injury. It was determined before this study even occurred what the mechanism was. This study is not how does one determine when it's unknown what the mechanism of injury is with regard to a decedent. And that feeds back into the lack of qualifications of Dr. Wolf, because we're not given one example of where Dr. Wolf, before his report, his 1-paragraph report on conclusions, of when he's ever done this before. It's not stated that he's ever taken a decedent and determined the manner of death. And I note that this study talks about mechanisms of injury, which scientifically is completely different from manner of death. And what it appears the Commonwealth is trying to do is to back into manner of death through the parlance of mechanism of injury, and that is not at all probative of manner of death. And lastly, this study only stands for the proposition of mechanism of injury. What they looked at is once the injury occurred, what were the mechanisms that were occurring through the brain? What happened inside of the brain that led to the various injuries? So this study doesn't at all, one, support any methodology, number one. It doesn't stand at all that this is the methodology for how one determines in a decedent what was the cause, because the cause of the injury was already determined going into the study. And it also doesn't state anything about the paragraph that Dr. Wolf has explicated in his report. And I will conclude with 2 points. Dr. Wolf says, based on the findings of his autopsy, it is clear. Well, the autopsy doesn't come to any conclusion on manner of death. The autopsy doesn't speak to mechanism of injury. So it is a non sequitur, Your Honor, to say that based on the findings of his autopsy, and we know from Dalbert Lanigan, you've got to apply your methodology to the facts and evidence in the case. And the only facts and evidence that Dr. Wolf uses, by his own words, is the autopsy, which doesn't support at all what he is stating in his report. The second and last point, Your Honor, is that it is not sufficient in the case law in Massachusetts. It's not sufficient under 702 for someone simply to come in and say, I'm a neurologist, I therefore know the brain, and then take the leap from that foundation into a conclusion with regard to manner of death. So in sum, Your Honor, he's not a medical examiner, he's not a forensic pathologist.
That's fair.
He has not stated any experience whatsoever in doing what he's doing here, meaning to determine the manner of death of a decedent. And his methodology is completely unsupported. We only have one article. And I've gone through why that article is insufficient. So we would request, Your Honor, and urge the court to exclude Dr. Wolf from testifying in matters beyond his kin. And in the alternative, we would request an evidentiary hearing because we and the defendant has a constitutional right to cross-examination. And this is the same with Mr. Gilman. It's the same with other experts where there is no statement of the methodology, as here, there's none, and there's no tethering to a study. And how is it that one can cross-examine a witness that doesn't even begin to approach the two prongs of the Daubert inquiry?
All right, thank you. Mr. Brennan?
Yeah.
May I?
Please.
Attorney Alessi mistakenly misstates Dr. Wolf's credentials. Dr. Wolf is not a neurologist, he's a neurosurgeon. He's not simply a neurosurgeon, and it's not that he's a renowned neurosurgeon, but he has over 35 years of experience as a neurosurgeon. In addition to his opinion, you can see that Dr. Wolf has an extraordinary history of experience as a neurosurgeon. His CV is attached. In his internships as a neurosurgeon, he engages in an internship in pathology, neuropathology. We can see from his major research interests includes treatment of head injury, spinal cord injury. Dr. Wolf was the leader and director of the Miami Neuroscience Center for 17 years, from 1993 to 2011, the busiest neuroscience center in the country. He has treated tens and thousands of patients with head injuries.
Treated them.
Surgeries. His professional memberships are too long to list. Page 3 of his resume. His research is broad and precise and specific to head injuries. We can see in his research listed on page 4, he's a principal investigator in THAM treatment of brain tissue, acidosis in severely injured patients, principal investigator, PEG, SOD, and severe head injury. Improving outcomes in severe head injury, PEG, SOD, also principal investigator, IRB protocol, brain pathology. He is well published. His book chapters that he listed anyways, list 16, many of them dealing specifically with head injury and brain injury. His book chapters include head injury and difficult medical management, pediatric neurosurgical emergencies, complication of head injuries in adults, imaging of craniocerebral trauma, imaging and trauma and critical care, emergency room assessment of head injury patients, intracranial injuries. He has numerous journal articles, a slew of them specific to head injuries. Intracranial pressure, number 2 on his journal articles. Initial management of brain and spinal cord injuries, number 9. Number 16, which is the document that I produced to counsel last night, listed in his journal articles, number 16. Fractures of the clivus, classifications and clinical features. His journal articles are numerous, too numerous to go through, but you can see that he is well published, over 70 articles. His presentations specifically on fractures, basal type injuries, number 5 on page 13. Number 9, neurosurgical management of traumatic brain injury. Number 10, acute head injury. And the list goes on. Over 90 references. Lectures and meetings, many of them dealing with head injuries.
Okay, quick question though. He's talking about how this neurosurgeon has treated patients with head injuries, but wasn't y'all help me remember because I may still be in vacation mode. Wasn't the whole thing he wanted Dr. Russell excluded because she was treating people with dog bite wounds, and that doesn't have anything to do, and the whole thing had nothing to do with treating the patient. It was about, okay, carry on. Tell me, chat.
100 lectures listed for reference, actually over 130, and a number of web publications. So this neurosurgeon who has this extraordinary experience is qualified. The ability to testify about head injuries and medical diagnosis and cause of death is not limited to a pathologist. In fact, I would suggest that the experience of Dr. Wolf is far superior to any pathologist. The difference is a pathologist treats patients that are already dead. Dr. Wolf treats patients that are in trauma, who some survive and many die. So he is intimately familiar, not just with looking at a deceased in a lab, he's intimately familiar with assessing the injuries after they occur, diagnosing what the injury is, and an attempt to save the person's life. And so he's well attuned after tens of thousands of surgeries to understand the causation of a brain injury and what causes death. Looking at Dr. Wolf's report, although short, it is clear that the injury that was occurred by Mr. O'Keefe was
2 different ones.
an injury known as counter-coup. And I dare say the defense proposed expert, Dr. LaPosada, is not in disagreement with that. To understand counter-coup, it occurs from a fall backwards on the ground. It can't occur from a bat or a punch or hit. There's not enough force. It occurs when the back of the head hits the ground and then the brain shifts to the front of the head. That is what the autopsy reports show. It may be that the medical examiner for the Commonwealth didn't have the same level of experience and didn't diagnose it, but this expert does have that expertise, and it is no different than the pathologist that's proffered by the defense. The periorbital ecchymosis that is directly related to the basal fracture, the swelling around the eyes, no different than Dr. LaPosada's opinion, exactly the same. One thing he doesn't say is that the body was moved. There was no evidence or information for that. He doesn't extend himself as a detective or put in unplausible theories in his proposed testimony. He is intimately familiar with counter-coup, having treated tens of thousands of patients, and he understands in counter-coup how it can lead to suffocation at the top of the spinal cord. And so his opinion is clearly supported by his extraordinary experience, his writings, his history. It can't be that his ultimate conclusions of counter-coup and ecchymosis, periorbital ecchymosis, is in dispute. It seems that the defense simply prefers the original medical examiner for the Commonwealth, but we expect to call Dr. Wolf, and I would suggest that he's more than qualified.
All right, thank you. Mr. Alessi, anything final?
Yes, thank you, Ron. Mr. President. Thank you. Your Honor, I'm going to note what Attorney Brennan did not state. He did not address at all how the methodology, to the extent it's discernible of Dr. Wolf, is commonly accepted or it satisfies any of the Daubert factors. And that is the fatal aspect of Dr. Wolf's opinion. It's not stated. You have to have either common acceptance or satisfaction of the 5 non-exhaustive Daubert factors. It wasn't addressed, and I think it's reasonable to conclude that it wasn't addressed because it doesn't exist. That alone dooms Dr. Wolf's opinions. I will stipulate, for purposes of this argument only, the cause of death prong. Let's assume, just for purposes, just to focus on manner of death, let's assume hypothetically that Dr. Wolf is qualified to testify about cause of death. Mr. Brennan did not address at all his qualifications to discuss and opine on manner of death. And that is the distinction I emphasize, Your Honor. Manner of death, he has not stated one qualification on manner of death. So the defense urges the court to draw the distinction, to limit his testimony to cause of death, not manner of death, because we know, and we cited the Graham article, which is attached to our motion, which specifies who is qualified to talk about manner of death. Because what does manner of death do? It takes into account all the circumstances surrounding it, the crime investigation. That's what medical examiners and forensic pathologists are qualified to do. Attorney Brennan cited that in his CV there's a reference to an internship in pathology. I looked, I didn't see it, but let's assume that it exists. Let's assume he has an internship in pathology. That does not qualify him to engage in manner of death 40 years later without any experience from that internship all the way until 2025. Lastly, Attorney Brennan goes through numerous studies, and I appreciate that he did, because the CV is almost endless with meetings, presentations. There's 4 peer-reviewed articles. That's it. 4 peer-reviewed of Dr. Wolf. None of them address or come close to the topic that he's talking about. My last point is this with regard to Dr. Wolf's qualifications and what his practice has been. And Attorney Brennan concedes it by his own words. He said cause of injury. And again, for purposes of this argument only, I will concede cause of injury. But manner of death was not addressed by Attorney Brennan. It's not addressed in any of the qualifications of Dr. Wolf, and it's not addressed in terms of the one paragraph that we have. And for something as significant as this, one paragraph that doesn't address common acceptance, methodology, Daubert factors, Your Honor, I don't know how a record is even begun to be established for him to be qualified or to opine on manner of death. So we would urge Your Honor to find that he is not qualified to testify about manner of death, that mechanism of injury cannot be manner of death, and that he be so limited to the extent the court desires and concludes that he has some relevance here. But in terms of all of the record that's presented, including the CV, etc., there's not one instance where we see that Dr. Wolf has even approached determining cause of death or manner of death at all. So I don't see where there's a record to find him being able to do that for the first time in charges of this nature. Thank you.
Okay. Do you want to respond at all, Mr. Brennan?
Of course he does.
at some point, arguments become semantical and theoretical, but not practical. This doctor has treated thousands and thousands of patients, many, unfortunately, which have died. And as a neurosurgeon, engaging in the operations and the study of the brain and the patients, it is obvious that the neurosurgeon would understand and appreciate why his patients are dying, because that is part of the study of trying to save them. So for him to reduce on a piece of paper that the manner of death is based on my thousands and thousands of patients and my years and decades of experience, seeing firsthand many of these patients I cared for or tried to help died, and this is why. Technically, he could do that if that satisfied Mr. Alessi, but that is so unnecessary because it's obvious. Thank you.
Okay. Thank you. All right, so we have a series of motions in limine. I'm going to start with defendant's motion to present the demonstrative exhibit on Christina Hanley's testimony. It's paper 558. Is there an objection from the Commonwealth on this?
There is an objection.
All right, so I'll hear the defense on this motion.
Thank you, Your Honor, if I may. This is a relatively straightforward and relatively short.
I have a question. Did you use this last time? It looks like
we attempted to use it. We had it last time. It was shown to the witness, but it was not allowed to be introduced. And all we're asking is for that next step, that it be introduced into evidence.
Did she adopt it? Was there? Okay.
She did indicate, and that's part of my argument, Your Honor, which
So I'll go ahead. I'll hear you.
I'll truncate it. It's a relatively simple request. We just want to use the chalk that was prepared in the first trial. No dissimilarity there. It was disallowed for use by the defense to be actually used, to be admitted, but it was shown to the witness. It was not shown to the jurors. The evidence, as the court will recall.
So let me just have, so you're just trying to use it as a chalk, not an exhibit?
No, we would ask that it be used as a chalk and an exhibit that's introduced. I'll take the chalk if the court wants to break it into two different pillars, but we believe that once the witness, and I anticipate based on her prior testimony that she would adopt it one more time for its authenticity or its accuracy, I should say, that it be used as an actual exhibit that goes back with the jury just for their help. The court will remember it's a very complicated.
So let me just, with that, if I allow it as a chalk, is there an objection from the Commonwealth?
Would be a partial objection to a chalk, some of the labeling. I have less concern of a chalk as I do an exhibit.
I mean, so we can take it in two steps. I certainly don't need to decide now whether it's admissible, and I couldn't. But what's the nature? Is this something?
The court will call this. This deals with glass. Christina Hanley spoke at length about her analysis of pieces of glass, other materials as well, but specifically as it relates to the glass, there were more than a dozen pieces of glass that she testified to. They were variously found in different places at different times by different people, and they're assigned a relatively complicated set of numbers that she utilized in her analysis.
And this is what you explained to me was the 47 pieces of glass that I asked you about last time, right?
No, this is more attended to the glass in the bumper.
Okay.
The glass in the bumper, the glass that was found at 34 Fairview, as opposed to the lens material that were the 47 pieces.
Okay.
Okay, so this is why this is a big deal. Remember, all of the stuff that was talked about with the glass. Y'all would be shocked how many people did not pick up on the fact that that glass, that Hanley said that glass on the bumper did not match the glass from the cocktail glass stuff that she had. So what they're wanting is, y'all know how when they're saying all of this information and all of these numbers and all of these exhibits and all of this stuff, it gets to be too much. And so it's going to be like that for a jury too. So what they're wanting is to, like, you know how I'll make my little diagrams and, you know, I'll say like, okay, like all of the words that they're saying out loud, here's a visual for that. So that's what they're wanting to do so that the jury can actually see, wait a minute, that piece doesn't go with that, so that it just makes it easier for them to understand. When these jurors are in there, that many hours a day, having to listen to that many people and having to listen, could you imagine having to listen to like Lally for that long and still try to comprehend all the information? So it's difficult. So this is basically saying, here are all of the words, here are all of the, exhibits, numbers, and all this stuff. She's saying all of these words to explain that this doesn't happen. We just want to show them a visual of what she's saying. And she did adopt this and say, yes, this is matching up to what I'm saying. They want to show that to the jury to help them better understand.
These were a bunch of pieces of glass that were that originated from multiple sources. Some matched each other, some did not match anything else. Some were from the same source, some were from multiple sources and different and distinct between and among each other. We reduced the very complex, the court may remember she talked about 7.14-B matched or didn't match 7.13-C, and it was very numerical and very difficult. It was difficult for me to follow. It was even difficult for the witness to follow because she continually had to resort to her own report as she tried to maintain her accuracy. So
Do you have the day of her testimony?
Oh gosh.
Ms. Little, do you have that transcript pulled up?
Yes, one moment.
He's based.
Obviously, I remember her testifying. I remember seeing this previously.
I've got it. June 5th, 2024, Your Honor.
Thank you very much.
Thank you, Ms. Little. The court will recall, and I think it's clocking with the court's memory, that we did use the demonstrative aid. We walked up to Ms. Hanley. We showed it to her on the witness stand, and she did adopt it, and she indicated that once she studied it, it was in line exactly with her testimony. It's an accurate visual representation of that evidence, and it just makes it a lot easier for the jurors to find some sort of linear logic to the evidence. What matched what and what didn't. And all we're asking is that we'll use the same aid, the exact same aid that we did last time, and just ask that it be used as not only a chalk, as Mr. Brennan said, he may have a slight objection to that, but also we would ask for the next step, which the court doesn't have to decide now. I think waiting on Ms. Hanley's testimony would be apropos, and then we'll ask for its submission at the right time.
All right. What's the objection, Mr. Brennan?
This witness has a report, and a report is not admissible and can't be shown to the jury. And so to have the defense summarize her testimony when she's not allowed to put her report in herself seems a bit imbalanced.
Oh,
There are
imbalanced. You talked
references
to me
on
about.
this.
Hold on. Imbalanced, sir? Are we really going to? Of all people to talk about things being unbalanced?
Potential chalk that lists troopers' names. Those names shouldn't be on there. But also, it doesn't give the full picture of the actual testimony. The issue regarding glass, I expect, is going to be a issue in the next case. And I say that because we learned last night, for the first time on a public airing of an episode, that the defendant suggests that Mr. O'Keefe took her vodka soda glass out of her car. Now, that is the first time we've had any statements from Ms. Reed suggesting that. And also, there was another statement regarding a claim that Ms. Reed pulled glass from John O'Keefe's face. Never heard that before. So we have this evolving or new testimony, or statement rather, statements about glass. And so I think first, I'd like to consider this new information that we just learned last night. And secondly, I am reluctant to agree to a simple summary of part of the witness's testimony that has not only labels on it, but does not, from my perspective, clarify anything. I'm not opposed to chalks. I think chalks are helpful for both sides. And I think the liberal use of chalks is helpful. But I don't have confidence this chalk accurately summarizes the witness's testimony. I'm open to discussing chalks with the defense and perhaps learning why they think this is helpful and important, but looking at this chalk, it does not look clear to me. And I do think that the evolving nature of glass in this case is going to be an issue. And since I've just learned this information, I want to give it some thought.
All right, so Mr. Jackson, what I'm going to do is just hold off and see where the evidence is, what the two of you talk about. Maybe there's some agreement you can come up with regarding this. I need to hear more of the evidence again.
I understand,
and I'm going to read the transcript, so that will help me with
I think
this.
it makes sense. Mr. Brennan indicates that the chalk was not helpful to him. With all due respect to Mr. Brennan, it's not really his understanding of the chalk that is going to sort of seize the day. It's Ms. Hanley. So I do think that if the court would keep an open mind,
Sure.
if Ms. Hanley testifies, then that would be the appropriate sign.
So I'll take no action on this, and maybe it's something we can address the day before she testifies or something as it gets closer.
Sure.
But the two of you should talk.
Sure.
I'm open to working with them if there's something they want to explain.
All right, great, thank you. All right, so no action taken on paper 558. So one question, the next motion I have is defendant's motion to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. The Commonwealth has a sort of maybe a similar one that I'm not sure. The Commonwealth's motion eliminate to admit the victim's out-of-court statement relating to his state of mind. So the Commonwealth's Bins and Qualls motion, does that address the Aruba witnesses? I'm just wondering if they're hand in hand. So the paper number on the Commonwealth is 585. It's got your 11 on it, though.
I don't think she should be doing any interviews or documentaries. I don't think she should be doing any of it. That's a fact. He watches TV and Twitter.
So the defendant's motion eliminate to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. It deals with the, let's just say the Aruba.
The Aruba stuff is so stupid.
Marietta Sullivan, Laura Sullivan. Does this, Ms. Giannetti, I think this was one filed by you, maybe it wasn't. Does this include the children as well?
This does not. This is
Okay.
limited. This argument will be limited to the, we'll call it the Aruba incident.
Okay.
Aruba's so
All right.
stupid.
So given that might not include the Commonwealth's number 11, the Qualls, Bins, the defendant's statement, the victim's state of mind as it goes to the defendant's knowledge and ability, likelihood to act on that state of mind.
The defendant,
So I just want,
I didn't mean to interrupt, Mr. Brennan. Do you want to?
so I just want to know if that is part of the Aruba one.
Okay.
so our statement relating to Mr. O'Keefe's state of mind is broad. It would have included the Aruba, but I can make quick work of this. We
Okay.
do not intend to introduce evidence about the Aruba event.
Okay.
I reserve the right, if the defense opens the door, then we may proceed with it. But in our case in chief, we don't intend to introduce any evidence from the Aruba event.
Okay.
Shortest
There we go.
argument ever.
All right. All right. So, Mr. Brennan, you can have a seat again, and we'll go through the defendant's one. That's very helpful. So I will endorse it as Commonwealth does not intend to introduce in its case in chief. If that changes, Mr. Brennan, you need to come to sidebar well in advance, okay? After telling counsel.
Understood. Thank
All
you.
right. All right, so that was 559.
The Aruba thing was, it comes across as such a stretch. It sounds like the Sullivan girls, maybe they are lovely in real life. However, the way that they come across on the stand is that, or at least the younger one, Marietta or whatever, she gets up there and she's like, yeah, Karen sucks. And, you know, whatever. It comes across very catty and mean girl. An argument in Aruba, you know, with a bunch of like grown women who were drunk or whatever. Like okay, y'all had a verbal disagreement a month before, and now you're using that as it was just stupid. It was a stretch. It was desperate, and it was literally just trying to get the jury to be like, oh, you know, Karen sounds like she can, you know, she can be whatever. It comes across as catty and nonsensical, and it just reeked of desperation, and it was the stupidest testimony I've ever heard in a trial. It was very drama queen, very mean girls. It was stupid.
The defendant's motion eliminate for review. Is the Commonwealth seeking a view as well?
We did not move for a view, but we do not object if the defense wants a view.
Okay. So who's going to argue this for the defendant?
I am, Your Honor.
Okay. So what's different this time around is you're asking that Ms. Reed be permitted to attend.
Yes, Your Honor.
So I'll hear you.
So this is for the, they had filed a motion for the same thing where they took the jury to Fairview Road last time, and then they had the jury look at the car. They're wanting to do the same thing, but they're wanting Karen Reed to be present for it this time. So that's what they're about to argue.
Your Honor, the defense is requesting that it exercise its broad discretionary powers to allow a view under Massachusetts General Law 234A.
So I'll allow a view.
Okay.
Okay, but let's talk about your client attending it.
Yes, Your Honor. There was a request in there for Ms. Reed to attend. That is something that's allowed under the law.
How do you propose that's done?
If it's possible to have separate arrangements for her to be there, vis-a-vis some other transportation so that they're not all on the same bus, if the court can make that accommodation, we would appreciate it. But the most important thing in this case, Your Honor, is that there be a view of both the vehicle and 34 Fairview Road.
All right, so the Commonwealth's not objecting to a view of the vehicle and 34 Fairview, correct?
I'm not, but I do not think the vehicle should be at 34 Fairview.
Okay, what are you proposing for that?
We could make arrangements and make suggestions, but it's not going to replicate the circumstances of that evening. And so it creates an image that is inaccurate. So I do not think that the vehicle should be sitting in front of that home in totally different lighting conditions, timing conditions, and I think it can be misleading.
All right, I need some suggestions. Why don't we table this for a bit, even if we do this one tomorrow? So one of the concerns I have about just logistically, people will have to stay away. When Ms. Reed's in court, there are a lot of people who come to court. So I need some assurances that there will be people kept at quite a distance. A separate car is fine. Would counsel plan on being in the car with her?
That would be fine, Your Honor.
So I need some proposal. So I need more information from both. So, Mr. Brennan, I'd like you to come up with a proposal about viewing the car a separate place or a separate time. It would be ideal if we could do it at the same time, but at a separate place, if that's what we decide. We may have to do it all at once.
I do think it's important, Your Honor, that the vehicle be at the scene just for dimension purposes so that the jury can get a sense of what it would have looked like at the scene. And I think just for convenience purposes, it saves a lot of coordination on the court's part and in terms of juror time by having it all happen in one fell swoop.
Okay. All right, so let's try and figure out some of the particulars. I would like to have Ms. Reed be able to attend, so let's figure out some particulars. All right, so defendant's motion eliminate to exclude certain witnesses before and after testimony. That's 462. And I think we can address the Commonwealth's motion for sequestration that moves to exempt family members at the same time. So who's arguing? 562, did I say 4? Sorry.
Yes.
562 and 576. So, Ms. Little?
Thank you, Your Honor. I'm handling the motion to exclude certain witnesses. The court has broad discretionary power to sequester witnesses before, after, and during their testimony under Massachusetts Rule of Criminal Procedure 21. The defense respectfully requests that this court issue an order for sequestration in keeping with what the Commonwealth also requested. But additionally, excluding Brian Higgins and members of the Albert and McCabe families after they testify.
So do you mean after the evidence is closed?
I mean, after they've taken the stand.
So after they've taken the stand, but so witnesses are sequestered not to influence any testimony. So once the evidence is closed, just before closing arguments, are you saying they should not be permitted to come into the court for closing arguments?
Yes.
Focus on that part of your motion.
Yes, Your Honor. We're asking that they not be able to attend closing arguments, and this is why. As the court likely recalls, at the first trial, members of the Albert and McCabe families continued to attend court after their testimony. During closing arguments, Colin Albert, Ryan Albert, and Jennifer McCabe were all seated in the jury box with the O'Keefe family. At least one juror who was seated in this case indicated to a reporter at Vanity Fair that she felt intimidated by their presence at closing arguments. Your Honor, a sitting juror reporting feeling intimidated by the presence of third-party culprits towards the close of the case is highly concerning.
Was this a deliberating juror?
I don't know. She was, or he or she was anonymous.
Okay.
And Your Honor, that was by design. There is information that the Massachusetts State Police and the District Attorney's Office wanted to have the third-party culprits seated there during closing arguments. And so on that basis, the defense is requesting, in order to protect there from being any sort of undue influence or intimidation, or even just the potential that a juror might feel that way, as we know it did in this case, we're asking that they be sequestered after their testimony and during closing arguments.
What's your position on the Commonwealth's motion to exclude the family members of both the defendant and the victim?
I believe that the sequestration order, yes, we join in that request.
Okay.
The only exception I would note is that experts should be able to obviously watch other expert testimony that deals with their.
All right, so obviously is not something that should be in a motion, okay? If you've got an agreement that each other's experts can be in the courtroom during the testimony, that's one thing, but it's not obvious that they're permitted, okay?
I forgot I muted myself when Lucy was barking. So she stopped Miss Little on saying obvious, but when Brennan got up there and said, well, he's obviously qualified, that was okay. Just carry on.
I just wanted to make sure that that would be excluded from the order that the Commonwealth proposed. Because the way that they wrote it, it says all witnesses. And I'm guessing that, and I won't speak for Mr. Brennan, but I'm guessing that they will want their experts to watch our experts and vice versa.
All right, so you all need to talk, all right? And if there's a disagreement, you need to put it in writing. Generally, experts are permitted, but it's not a given, okay? All right, Mr. Brennan, do you want to weigh in on people being able to, I'm concerned about after the evidence is closed.
I think it's unfortunate that not only a time-honored tradition, but an entitlement for a witness after the evidence is closed to come into the closing and watch the closing. The defense tries to take an opportunity to provide an unsolicited bashing on their targets.
Oh God,
They
shut up.
name Higgins, Albert, they invoke those names, they characterize third-party culprit, and they suggest that someone.
As we're listening to what he's saying right now, just keep in mind that thing about feeling intimidated came directly from a juror, It has nothing to do with the defense bashing anybody. But this is what Brennan does. He twists it because his big thing that he's doing here is making the defense the bad guy. Brennan is very calculated in how he's doing this. He is trying to fight this in the public, as opposed to fighting this with a fair trial. He is right now trying again to make the defense the bad guy when the defense had nothing to do with this. This came directly from a juror saying that they felt intimidated by Brian Albert looking directly at them. And it was said to Vanity Fair, and it was said in Juror Ronnie said the same thing. If you don't care how a jury perceives that situation happening, then that says everything you need to know about him.
Anonymous person was uncomfortable. It seems as though the presentation has a deliberate point to promote a cause, but it doesn't have any sense of balance or fairness whatsoever. All witnesses from either side should be able to come into a courtroom after the evidence is closed, the sequestration order has ended, and watch a closing. Grace can be offered in these circumstances sometimes, and that's what I've tried to do in my motion. Ms. Reed has 3 potential family members who are potential witnesses for the government, and certainly I would have a right to try to ask the court or insist that they should be sequestered. But I've specifically asked that they not be sequestered. I think that an accused has a strong need to have family support in the courtroom. It's not in the benefit of the government or the Commonwealth, but it's fair, it's just, it's graceful. And I think that Ms. Reed's family should sit through the court testimony, even if they're called as witnesses, as should Mr. O'Keefe's immediate family. The idea that witnesses should not come in after a evidence rests and during a closing, not only does it seem quite unfair, it doesn't seem to have any basis in law, in justness, in courtesy. And so I ask you to deny the idea that these targets of the defense should not be able to attend the closing. But I do ask you to endorse my motion that would allow family members to have the benefit to sit through the court proceedings, even if they may or even if they do become witnesses.
Okay.
Your Honor, if I could address one issue.
Sure.
There is some additional information. I was hoping we might be able to address sidebar because it is subject to a protective order, but I would like to make a record.
So another thing, if I remember right, didn't Paul O'Keefe say in one of his interviews that they specifically wanted the jury to see them sitting with the family during closing? Chat, tell me if I'm remembering that wrong, because it's been a while since I've seen that. But didn't he specifically say that he wanted the jury to see that the third-party culprits that were introduced from the defense were sitting with him so that the jury didn't believe it or whatever? Which is like kind of exactly what influencing a jury looks like.
All right, so Ms. Giannetti, I think this next one might have been yours. I could be wrong again. Maybe it's just that you filed some. It's paper 565, defendant's motion eliminate to prohibit testimony regarding funds paid to experts for purposes of voir dire.
That's also mine, Your Honor.
Okay.
I believe the Commonwealth has indicated that they will agree to that.
Okay.
Okay, all that one was is thank you, Zach, for the super chat. All that one was is the cost about the voir dire, where they had to, at the Commonwealth's request, bring the ARCCA experts in for a voir dire. They didn't want that brought up during the cross-examination as like a, look how much money they spent, to make it sound like they were, being paid this huge amount, because the cost of bringing them in for voir dire was expensive. They didn't want it to be misleading to the jury.
All right, so paper 565, allowed by agreement.
Correct.
So 566, defendant's motion for panel voir dire. Who's arguing that?
That's me, Your Honor. Thank
Okay,
you.
so all I need you to really focus on, of course, I'll give attorney conducted voir dire, but why don't you focus on panel voir dire for me?
The request is pretty straightforward. We would maintain a categorical list of topics that is in line with the statute, previous experiences with the criminal legal system, characteristics of the case, including media attention, things of that nature, biases in favor of law enforcement or vice versa, personal beliefs about driving under the influence. We think that's attendant to this particular case in particular, involvement in any relationships involving domestic violence, involvement in motor vehicle crashes, those categorical issues, whether they've ever been victims of violent crime, and their general ability to be fair and impartial in light of Ms. Reed's constitutional rights to.
Okay, well, we covered all of that last time as well, right?
And that's exactly right. So we're not asking to change the categorical subject matter. We just believe that a panel voir dire conducted, at least in part, with limitations, obviously, time limitations and subject matter limitations by the attorneys, would be of great assistance to both counsel, both the Commonwealth and the defense, in determining jurors' ability to sit through an extensive trial, a complex trial, and something that's going to be obviously hotly contested. The chemistry between and among jurors is more borne out if there is some, at least a modicum of panel discussion between and among the jurors and counsel who will be handling the case on behalf of Ms. Reed and on behalf of the Commonwealth. We don't think that there's any prejudice to either side, certainly not to the Commonwealth, certainly not to us. I think all of us would benefit, including the court, would benefit from being able to impanel a fairer and more comprehensive jury.
Okay, what's the Commonwealth's position?
Of course, we defer to the court. However, we prefer a questionnaire. If we have a panel voir dire, there will be quite a bit of contest on the subject areas, the limitations, the parameters. I wouldn't say anticipate, but I worry that it will digress into trying to craft the argument, the direction of argument, in a way that's favorable to each side's cause. And that really isn't the purpose of it, but that seems to happen in the limited times I've engaged in it. And so I think the questionnaire is more structured. It allows for all the different subject areas that are important to both sides. And I may misunderstand, but I think the court allows follow-up on questions where there is any inquiry or concern or a follow-up that's reasonable and necessary. And I understand that that has been a liberal application, and I think that suffices.
The only thing I would say to that, if I may speak from here, the only thing I would say to that is I completely agree. I think a questionnaire is enormously helpful, especially as it pertains to a panel voir dire. And quite frankly, Your Honor, in my experience, and that's what we do where I'm from, is panel voir dire consistently. It's faster. It's actually much more efficient to do a panel voir dire than it is to do an individual voir dire. That's all I'll say about that.
So I'm a huge proponent of panel voir dire in the right case. My biggest concern here, frankly, if we didn't have the inordinate amount of publicity on this case so close to trial. I heard that there was something last night. It's been in the news, right? And it's continuing. It's because of that, I'm afraid it's just going to blow up the panels. So, and I have a lot of discretion here. I'm not going to allow panel voir dire. I will allow a robust, as I did last time, voir dire at sidebar. We're also on for final trial conference today and tomorrow, so I need a list of witnesses from the defense. I need you to fill out a report so that we know exactly what is still left that we have to deal with. And jury voir dire is a very important part of this. So I expect, as last time, to be able to use a questionnaire, but I want you to agree to it. And if you can't, I need that. I need that by the end of today if you're not going to agree to it. Have you proposed a questionnaire? Have both sides talked about a questionnaire recently?
We haven't, but we do have the advantage. Both sides has the advantage of the one from last year. There may be some adjustments, but I think we've got a backbone to start with.
So let's do that. What Mr. Brennan's new to the case, what I need in a questionnaire is it has to be one page, both sides, no more than one page. At the end of our hearing tomorrow, I would like to talk about the particulars of it. We have a huge amount of jurors coming in, and I have some ideas on how we might best utilize that with the questionnaire, but I need to talk to counsel about that at the end of all these hearings today. All right, but just to be clear, no panel voir dire on this case, unfortunately, I think because of all the publicity. And we'll do extensive voir dire at sidebar and the questionnaire. So 566 then is denied because it's requesting panel voir dire. 567, defendant's motion for order prohibiting the Commonwealth and its agents from speaking with or having contact with any witnesses once they've taken the stand. So is there an objection to that, Mr. Brennan?
There's not. I believe that rule should apply to both sides. I have no objection.
Okay. Mr. Jackson, do you agree it applies to both sides? Ms. Little?
Thank you.
Okay.
Sounds easy enough.
All right, so that, Mr. Clerk, 567 allowed as to both sides.
I love it when they agree. Doesn't happen often.
.570, defendant's motion eliminate to exclude irrelevant, inadmissible, and prejudicial evidence regarding alleged harassment and/or intimidation of witnesses. All right.
Thank you, Your Honor. The first trial, I'll note, was riddled with what we believe to be inadmissible and highly, highly prejudicial testimony from a bunch of witnesses who took the opportunity to describe harassment and distress that they felt from third parties, both on social media and otherwise. No third party, including any blogger, any social media personality, any member of the public, no third party speaks for Ms. Reed. No third party speaks for the defense. No third party acts on behalf of Ms. Reed, is directed by Ms. Reed or the defense, or is under Ms. Reed or the defense's control. None. There were very obviously vile acts that were described during the course of the first trial in these witnesses' testimony. To the extent that they did occur, they are obviously in no way condoned by the defense, by Ms. Reed, or anybody connected with the defense in this case. And they're in no way connected to Ms. Reed or the defense. And notwithstanding that, the witnesses strongly suggested that Ms. Reed and the defense itself were somehow responsible for these alleged and very reprehensible things that they were describing. In one notable instance, Jennifer McCabe recounted being harassed by a blogger. She didn't name the blogger, but she said, quote, "The defense is very familiar with this person," end quote. That was her trial testimony, and she looked right at the jurors when she said it. The very obvious overture was, "You know who this is, Mr. Jackson. I was the one cross-examining her, and you're responsible for it." In some way, shape, form, or fashion. She outright suggested to the jury that Ms. Reed and the defense were responsible for the acts that she went on to describe in great detail, in which we agreed, if they occurred, are vile, reprehensible, unacceptable. There are clearly, as we all know now, there are clearly people out there who are very deeply concerned about what they consider, the others consider, an unjust prosecution of an innocent person, for a crime that she did not commit. There's an enormous amount of emotion injected throughout the community, this community and beyond, and we don't control that. And if people have suffered as a result of that, Ms. Reed very specifically should not be the one to have to bear that burden, and she did in the first trial. Those individuals out there who are emotional about the case, who are a proponent of one side or the other, they speak for themselves, they act for themselves, they act on their own accord. They certainly don't act at the direction of the defense or of Ms. Reed. And to allow these sort of what ultimately can only be described as salacious anecdotes into evidence, coupled with the sobbing and the crying and the breaking down on the witness stand, which also happened, it serves to visit an extreme and an extraordinary prejudice against Ms. Reed, very, very specifically and very targeted like a laser on her. And it's for conduct that's completely out of her control and completely unassociated with her. What may be most galling about the Commonwealth's presentation of this evidence in the first trial of witness intimidation was that they were in possession. They actually knew. Mr. Lally, Ms. McLaughlin, they knew at the time the information was presented and propounded in front of the jury that a grand jury had been impaneled to hear evidence on whether or not Ms. Reed was in any way liable.
It's the big deal.
For witness intimidation, witness harassment, or anything associated with that.
So the grand jury has a particular standard, right? Not any way, right? Probable cause standard, right? Okay.
But notwithstanding that standard, the question was she in any way liable for that harassment and intimidation? And that standard is extremely low. We all know the ham sandwich anecdote.
I've used that in the
even the
podcast.
grand jury said, no, there is absolutely nothing to see here. There is no evidence that she was responsible for intimidation or harassment such that they determined that there was a no bill. And what is bothersome is that the Commonwealth was aware of that and didn't disclose it. We didn't find out about that until in October. I think it was an October notice of discovery when we finally found out that a no bill was issued indicating that Ms. Reed.
When was that no bill issued?
You said when or where?
When?
When? I want to say March 23rd, March 27th is what I'm being told. It was late March, before the first trial. And they knew this, and they didn't provide what I believed, and I think what the court would have ruled would be exculpatory information to us to cross-examine these witnesses who say, hey, look, I've suffered at the hands of the community, of these bloggers.
So my memory is I kept it out, and then I have a very clear memory of you opening the door with Jennifer McCabe, and it came in through there.
So the court did make that ruling that ultimately, if the door is open, these witnesses are going to be able to talk about it.
But I kept it out prior to that.
Understood.
Okay.
I don't want to revisit that issue. The court made its ruling. I didn't think that we had opened the door. It was whatever that door was. It was on some very, very significant lubricant. It was going to be very easy.
Read the transcript.
I have several times. In any event, I believe that the court should make the exact same order this time and have a more defined, we should have a more defined understanding of what would reasonably open that door. I didn't think that I came anywhere close to it. The court disagreed and the information came in. But it's so prejudicial. It was so extremely prejudicial as to Ms. Reed that I think we need to revisit that issue and get a more clarifying order about exactly what would be required to open that door. And then we can reasonably, as the defense, we can reasonably sidestep that as best we can. I wasn't able to do that in the first trial because I didn't think that I had even approached the line, but ultimately the court disagreed. So what we're asking in this instance is that we get a clarifying order that it is not admissible. Obviously, if we walk in and say something about witness intimidation, you've never been intimidated by anybody, have you? Obviously, that would open the door. That's not what would happen. That's not what happened last time. What happened last time was Jennifer McCabe basically decided that she wanted to talk about that issue and sort of walked through it, at least in my view, having reviewed the transcript. In any event, I think the court understands what our concern is with regard to this subject matter. We don't want a free-for-all of people, one person after another, walking into court and basically lambasting the defense, for all intents and purposes, about things that are completely out of our control. Even if there is some suffering by the public or by bloggers or by whomever that these witnesses have had to undergo, that is not at the hands of the defense, and we shouldn't have to misread very specifically, should not have to suffer through that testimony when it looks very, very clear that at least the Commonwealth wants the jurors to believe this is all at the hands of Ms. Reed, that she's been the one engaging in this, which is, or the defense has, which is just not true. So we would ask for a clarifying order on that issue very specifically.
Mr. Brennan.
Like this is going to be snarky.
I can appreciate the defense wanting to identify the line in which they would open the door to evidence about harassment and abuse of witnesses. I understand why that would be important. But to convert that into a speech that absolutely defies reality and grossly misstates the history and facts of this case is beyond me. It wasn't just last night when Attorney Jackson and his colleagues appeared on a documentary where Ms. Reed talked about speaking frequently to Mr. Carney, sharing anything public with him. And you would have to choose to be oblivious to think that that information that is shared was then not generated to intimidate and harass witnesses for 2 years. In fact, Mr. Carney has over a dozen indictments for just that. You've had an opportunity to hear the conversations recorded with Gretchen Voss. You've heard about the tactics used by the defense in the dissemination, not just of public information. So to try to make a public record that is so grossly, not only inept, but fraudulent, I don't understand the purpose of that when the simple question is, what is the threshold of opening a door? We have a motion later this afternoon in another courtroom on this very issue. And I'm not going to go through an entire resuscitation of the evidence or information that I have, because that inevitably would be unfair. But it is unfair to stand up here at this podium and suggest for a second that Ms. McCabe is using a witness box as some type of forum. She didn't drag herself into this case. She was dragged into it. And to suggest they can stand here and bash witnesses in the text of their argument, unsolicited attacks, because it pleases them and fits their narrative, is something I can't just sit by and listen to. The Commonwealth, the prosecutors weren't outside patting their bloggers on the butt for a job well done after witnesses were harassed at their family events. That didn't happen. And so if the issue is, what is the threshold when Mr. Jackson opened the door? Well, you can read the transcript. It's very obvious. Open-ended questions, personal attacks, baseless accusations. That opens the door. And it will open the door again, I suspect. And we'll be prepared. I think the issue is really a trial issue, and an attorney having control of their questions so they don't open the door. That really is the issue.
So do you agree it doesn't come in the Commonwealth's case in chief with these witnesses?
I don't think it ever should have come in the case in chief, and I don't think it would have until I saw the very clear questions that opened that door. I have no intention of raising a collateral issue or trying to present prior bad acts that I haven't sought admissibility for. So I agree. I agree.
Okay.
Oh, the soapbox.
Your Honor, if I may very briefly.
Sure, just give me 1 second. I want to take one note, okay?
Of course.
All right, go ahead, Mr. Jackson.
I just wonder if where this ire and these invectives from Mr. Brennan come from. He said that I stood up here just a second ago and attacked witnesses and bashed witnesses and made fraudulent statements. Was he listening? I didn't bash a witness. I didn't attack a witness. I didn't make any fraudulent statements. The Commonwealth made their best effort to tether Miss Reed to Aiden Kearney. And they did it through a grand jury. And those members of the grand jury said, no, it's not true. It didn't happen. That's what they said at the lowest burden known in criminal justice.
That's true.
So Mr. Brennan can stand up all he wants and say, I saw a TV show and I saw this and I heard an interview, and clearly there's been communication between Ms. Reed and Mr. Kearney. Sure, there may have been communication. That's very different from directing witness intimidation, directing witness harassment for the purposes of undermining a prosecution. That's what they've accused her of. And they failed. And then they kept that from us when they failed and allowed this sort of fabrication of the witness. And I'm not saying that the intimidation that was described on the witness stand was fabricated. That's not at all what I'm saying. Maybe it was true. Maybe it all happened. What was fabricated is that it was connected to Ms. Reed or connected to us. So nobody's up here, Your Honor, and I take issue with Mr. Brennan's tone and tenor. We can all be professional. We can all advocate very zealously and robustly. But let's keep it professional. I didn't stand up here and attack a witness, or what did he say, bash witnesses, use this as an opportunity to bash people. We could calm the drama down just a little bit and probably get a little further. All we're asking is that it not come in, and I will stipulate and agree with Mr. Brennan that this not come in the Commonwealth's case in chief, and we will be very mindful of what would conceivably open a door to this kind of testimony, and I'll probably seek the court's guidance before I ask a specific question that I think comes anywhere close to that. We'll ask the court's guidance by coming to sidebar, and I think that could resolve the issue.
Okay. Thank you. I'm going to look at this a little more closely.
We'll see. I think that they want to say it on the
All right,
stand.
the next one is paper 571, and the Commonwealth's corresponding is your number 12, our paper 586. So the defendant's moving to exclude the serum plasma ethanol concentration, blood ethanol concentration conversion, and corresponding retrograde extrapolation analysis. So who's arguing?
Okay, so this is the extrapolation. So this is the one where they took her blood when she was at the hospital, and then they used that blood sample that was taken from the hospital to do the extrapolation, where they gave that big wide range of her estimated blood alcohol level. They're wanting to have that excluded. So that's what this one is.
Doing this for the defense because I'm going to ask you whether you want to argue your opposition to it or have the Commonwealth make their argument for admission of it. Who's arguing it for the defense?
Your Honor, I am. And to answer your question, the defense preference would be for the Commonwealth to go first, and we would respond, including with regard to my motion.
Okay. So, Mr. Brennan, our paper 386, your number 12.
Your Honor, paper number 12 seeks to admit the results of the defendant's blood draw at the Good Samaritan Hospital and the resulting serum conversion and retrograde extrapolation. This being a OUI manslaughter and murder case, the statutes that the defense cites don't apply. This is not a simple OUI case. We expect that we will have a witness from the hospital describing the protocol. We will have a witness from the hospital to testify about the blood draw, and we will have an independent, or we'll have an expert to talk about the blood serum conversion. These medical records are admissible. We've cited Chapter 233, Section 79 as a business record. I know the defense takes issue with that. However, these records are routinely admissible. Commonwealth v. Hallinan, 491 Mass, 730, page 736, note 9. Blood alcohol serum conversion and retrograde extrapolation is admissible. While the standards may be different because it happened at a hospital, these are agencies, hospitals are facilities that have standards that comply, that are trustworthy, and this evidence.
Okay, real quick. The issue here is that if you remember from the first trial, the standard for this to be used for the Massachusetts State Police to have, stuff like this that can be used is they have a specific list of standards. Okay, the hospital has their own specific list of standards for how they draw blood and how things are done. So the hospital standards were abided by because it was the hospital who did this. But Karen Reed's blood was never taken by a member of Massachusetts State Police. So they were able to do the retrograde extrapolation and the conversion, and they used the sample that was drawn from the hospital to use their conversion and stuff like that to get that that very wide range of the blood alcohol content level. But if you'll remember, the guy who did the report on that said specifically that because it was not a blood draw that was done from a Massachusetts State Police, it doesn't actually meet their requirements for providing this as one of their, I can't remember the exact words, you'd have to go back and check it, it's been a while, but it doesn't meet their exact regulations on how they would have to report for it. So that's where the argument comes in, is the standards for the hospital were followed, but not the standards for the Massachusetts State Police lab.
Should come in pursuant to those cases in that statute.
All right. Now I'll hear you, Mr. Alessi.
Thank you, Your Honor. Attorney Brennan misstates our position that is clearly set forth in our papers. We are not citing to statutes that discuss consent of Ms. Reed. So I just want to take that because he's conflated issues and not addressed the main issue. Attorney Brennan just said that the results are reliable. And I appreciate very much that he has raised that, because not only is there no proof that the results are reliable, there's proofs in the first trial admissions as by Mr. Roberts, as well as impliedly by Ms. Knowles, that they're not reliable, and here's why. There is no record evidence as to the method of the hospital determining those levels. Specifically, with regard to the medical records in the chemistry section of those, it says in an annotation, the drug testing, this report is intended for use in clinical monitoring and management of patients. And here's the key statement. It is not intended for use in employment-related drug testing or court-related proceedings. And the issue with regard to the reliability of the testing is it is not stated the basics to go to reliability. Specifically, there's no documentation of how the alcohol test result was obtained, through what procedure, by whom, and the key, what manner of testing. There's two ways to do it: gas chromatography and enzymatic testing. And there's a huge difference in the reliability between the two. There is no record evidence, and it's the Commonwealth's burden of proof to establish reliability. There's no evidence of any of those foundational aspects with regard to the testing. So with regard to those test results, the Commonwealth has to establish the reliability. It is not enough for the attorney for the Commonwealth to simply to stand up and ipsy dixit in saying they're reliable when there is a lack of the information of the factors I just rehearsed with regard to the matter. And another key aspect, which is conceded by the Commonwealth, they concede that the testing did not occur at an accredited laboratory. They concede it. And it's in every single report of the Commonwealth. And we put that in Exhibit A to our motion. For example, it's Exhibit A, the very first page, COM 000994, serum plasma conversion report. It states, 2 paragraphs under the chart, with an asterisk, the ethanol result used in this serum plasma conversion report was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory, and therefore this report does not fall under the laboratory scope of accreditation. Not the words of the defense.
So that's from the State Police Crime Lab, right?
Pardon me?
That's from the State Police Crime Lab, right?
That's correct. And with regard to the next document, which is our Exhibit B, in terms of changing that conclusion in that statement, there is nothing in there to remedy that statement. Exhibit C also mentions, and this is NDAO 296, under background, it's the same statement. The ethanol result used in this retrograde extrapolation report was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory. So what we have with regard to the foundation of reliability, we don't know what type of test result this third party did, gas chromatography or enzymatic, and we don't know any of the other factors, and it's the burden of the Commonwealth to establish the reliability of that testing. So in conclusion, Your Honor, given that the Commonwealth has not satisfied its burden in this regard, the testing that has been performed is not reliable.
All right.
It should be excluded.
Okay. Do you want to respond, Mr. Brennan?
I would suggest the court look to Dr. Fowler's testimony. He testified how blood was taken, how it was preserved, what tests were conducted in the lab at Good Samaritan Hospital, how the lab is accredited. And this is the same issue argued at the first trial, but inevitably Dr. Fowler's testimony is what establishes the foundation for the admissibility.
Okay.
May I just respond briefly?
Sure.
Thank you, Hunter. Your Honor has often said that this is a new trial. The Commonwealth for this trial has to establish that foundation. They can't point to the testimony in another trial to establish it. That should have been in their motion in opposition, that they should have put that in assuming that that is accurate. But it is not in their motion here, and that cannot be relied upon to defend the lack of reliability with regard to those factors.
That's a
and
good
I will
point.
also note that none of the witnesses I just rehearsed, Mr. Roberts nor Ms. Knowles, if we're going to talk about the first trial, ever referenced that as curative of what they said for lack of accreditation. And if we're again going to go back to testimony of the first trial, Mr. Roberts on cross-examination clearly expressed concerns with regard to these foundational absences with regard to testing. Thank you.
Okay. I think we have time for one last motion before we take the morning recess. Paper number 574, defendant's motion eliminate to exclude witnesses' prior criminal history. Who's arguing that for the defense? Is there no objection to this? This is regarding Richard Green.
It doesn't qualify pursuant to the statute.
All right, that was my question to you. How do you expect to get it in?
I don't.
Okay. All right, so this motion is allowed. That's 574 is allowed, Mr. Clerk.
That one was for Richard Green, is that right?
All right, so what I'll do is I'll see counsel at sidebar regarding scheduling.
Jury selection starts on April 1st. Oops. Let me see. We're behind just a few minutes.
All rise for the court, please.
You are muted.
We'll be recessed 15 minutes.
Recess 15 minutes. And let's see, we are, all right, now we're back live. Okay, so I'll take these off my ears for a minute. Oh. All right, so we're moving right along. We're getting down through some of these. So let's do quick recap on this. The biggest thing so far has been the stuff this morning with ARCCA. I'm still really frustrated over that. I'm still really frustrated over that because that whole, energy that she came with toward the defense about ARCCA, as many misrepresentations and false statements as Hank Brennan has made directly to the judge over and over in court. And she doesn't come with that same energy to him. And that's really, really hard to watch. That's one of the things that makes this case really difficult, because when you see stuff like that, it's like, okay, where's the outrage on the other side? That's the part that is hard for me, because if you need to reprimand one side, you should also be reprimanding the other side for doing, exactly the same thing, but also a lot more often. And that part is really, really frustrating to watch. As far as the Dr. Wolf stuff, so the Dr. Wolf was the next big motion that, or I guess the first motion that they actually argued today. Now, this is not crash. This is the neurosurgeon, Dr. Wolf, that the defense wants excluded. So Alessi says basically that it's not enough for him to come in and say, I'm a neurologist, I know the brain, and then leap to a conclusion about the manner of death. Brennan said, that Dr. Wolf had an internship 30 or 40 years ago, and so he's qualified, whatever he said. I'm paraphrasing because I'm annoyed, so my snark is a little bit out of control right now, but that's okay. So that one, of course, she is not made any ruling from the bench. We will get a ruling on that later. But that is the argument, of course, Alessi made too. He did not address any of the methodology, and he didn't satisfy any of the Daubert factors. I wouldn't hold my breath on this one because we have seen, based on the rulings that Judge Canoni has made recently, that she is going to side with the prosecution, even when it is right there in black and white that, you know, she's denying it for the defense and then allowing it for the prosecution. It is wild to me. And it's, you know, I said it's very frustrating, but when I'm also seeing so many attorneys, you know, the whole thing that we do here is we look at this like a juror does, right? But I also, on some of those things, I'm like, am I crazy? Am I like, this can't be normal. This is not how things are supposed to go. Am I crazy? So in those situations, I will turn to attorneys and hear their perspectives, and not all attorneys. The ones that I, you know, think are generally like very balanced and level-headed, and seeing them like, holy crap, you know, I'm like, okay, I'm not crazy. Like, that's really bad. You know, that looks really bad. So, so because of that, I wouldn't hold your breath on the ruling on this one being, you just can't tell. You just don't know. So we'll see what she says. Now, as far as the demonstrative for the glass, we talked about that one a little bit. That is the chalk that they had made from the last trial, where the cocktail glass that was thrown, I'm not saying it was thrown. I'm saying the ones that they talked about, where ARCCA said that, you know, they had tested it to see if maybe the glass was thrown. That was one of my theories from the beginning, is that, like, you know, if they were arguing because she didn't want to go in and he did, then, you know, maybe he threw the glass. I had said that, and then ARCCA said it. So that's the only reason I'm saying thrown. But that was testimony from Hanley, whatever her name was, the glass lady. So she put together, you know, all of these numbers, and it's very numerical stuff. And so it's hard to comprehend exactly what she's saying. And the fact that the piece of glass on the bumper didn't match the cocktail glass, that's a fact that kind of got missed by a lot of people in the last trial. So they're wanting to basically have this like visual for the jury to see that, and they want it to be admitted into evidence as well, so they can take a look at it. Brennan has an issue with that. Of course, Brennan has an issue with everything that would help the jury see anything that the defense is saying. So he says it's unbalanced, and he doesn't want the troopers' names on there. The troopers who found each of the pieces of glass, I guess, he doesn't want the troopers' names on there, and he says that that he thinks that it's an oversimplification, or it doesn't fully show her testimony, even though she you know, acknowledged that that's what she was saying. So whatever. The Aruba stuff, which is, like I said, just completely nonsensical and desperate to try to bring that in as a motive for murder, but whatever. Lally tried it. He gave it the old, you know, what is it? The old, what's that saying? What is it? The old college try or whatever. Anyway, he gave it a go. And we've heard from juror interviews that they all thought that that was like stupid. It didn't have any effect on what they thought. So Brennan says he does not plan on introducing the Aruba nonsense unless the defense opens that door. His idea of how that door could be opened, the old college try, that's okay, yeah, it is. Do you ever have sayings where sometimes like you say it and then it doesn't seem right in your head? Anywho, so he doesn't plan on introducing it unless they open that door. Now, I don't know what he would consider that door being open, how that, you know, but we'll see. The other one that we have talked about this morning, or another one we have talked about this morning, is the view of Fairview and the Lexus. So how the jury went last time and saw Fairview Road, they saw the yard, and then they saw the Lexus that was parked out there. They're wanting that to happen again, but they're also wanting Karen Reed to be there this time. There doesn't seem to be an issue with Karen being there. but Brennan does not want the Lexus at 34 Fairview. He said that it creates an image that isn't accurate because of different lighting and weather or whatever. To me, that makes no sense. I think that it's important for the jury to see the car. It doesn't matter if it's snowing when they look at it. It doesn't matter if it's dark when they look at it. I think that the whole thing about seeing it is the perspective of the size of the yard, the perspective of the car, and all of that. So we'll see what the ruling is on that, but he does not want it to be there. I feel like even though this is like the, judge doesn't tend to like to give the defense anything that they are asking for recently, I feel like this is one that she would approve because she's not going to have to work out the logistics of having to do a separate viewing for the car and the and the yard. So we'll see what they say on that one. The sequestration was the next thing. The defense has asked for the third-party culprits who came in to watch the closings last time, for them not to be allowed in this time, because they had talked about some of the jurors saying that they felt like it was intimidating, and it's, done specifically to make the jurors, right at the end of trial, make the jurors think a certain thing or feel a certain way or influence how they feel about something. And so they're wanting that to not be allowed this time. Brennan, of course, says that the defense is taking unsolicited, their unsolicited bashing of targets, or however he worded it. He says that it doesn't have any balance or fairness. Every time he talks about balance and fairness, it just makes me roll my eyes because there has been so little balance and fairness in this situation. So, whatever. So he does not like the idea of them not being allowed to come in for the closings. So we'll see. The defense has asked for the money that they had to pay for ARCCA to come for the voir dire, for that not to be brought up because obviously that's a big expense. They only had to pay them because the Commonwealth specifically requested that they come in for voir dire, and so they've asked for that not to be included in the cross-examination about what they paid. That was agreed on, so that one's no big deal. The panel voir dire that the defense requested is not going to happen. Bev says that that is not a good idea because of all of the publicity around the case lately. She said that she thinks that would blow up. So basically, instead of like it, how we've seen in, well, I guess y'all haven't been there for jury selection. So in some of the trials, they will come in and they'll talk to the entire group. Like, has anybody, heard about this or whatever? And most of those cases are not so high profile. They're not as big of a deal with, doing panel stuff, because you can get a lot more answered in a shorter period of time with a panel voir dire, but you are opening the situation up to where somebody can say, oh yeah, I've heard this, and she's like my cousin is Marietta Sullivan and she says she sucks, or whatever. There was actually a voir dire in a case here where the guy knew, and I got this from the transcripts, I wasn't there for it, but it's one of the cases I covered, but I got the trial transcripts after, and I got the voir dire transcripts too, and it was interesting because the potential juror said something about during the voir dire, he's like, yeah, I know him. He's like, yeah, he sucks. Like, he got, my ex-wife cheated on me with him, and there was like this whole like baby daddy drama about like who was the father, was it him or the defendant? And so anyway, it was crazy. And that was done in front of a panel. So there are things that can, when she says that there are things that could, blow up the panel, it's stuff like that could be potentially, brought up in front of an entire panel of jurors that could then make a big, make it to where like you can't unring that bell. So that has been denied. They will not do the panel voir dire for the jurors on this. They will do the questionnaires and they will do questioning at sidebars. Both sides agreed to the attorneys not talking to any of the witnesses after their testimony. The harassment and intimidation of witnesses, that was something that they kind of got a little snarky with each other over this one. Brennan says that he doesn't plan on introducing it. He doesn't think it should have been introduced at the first trial, but he, which is also interesting because, okay, then why did you put Turtle Boy on the list? But, well, I called it from the beginning. I think he put Turtle Boy on the list so that Turtle Boy couldn't be in the courtroom and couldn't watch the trial, but that's just my pure speculation. So anyway, the harassment and intimidation of witnesses, they say that it's that he's not planning on bringing it up, but he says that he suspects that the door will be opened again. So we'll see how that one goes. And then the extrapolation, of course, that one is something that was talked about during the first trial. I couldn't remember the word earlier when I was explaining this. It's accreditation. The Massachusetts State Police said in their report that because the blood was taken from the hospital and it wasn't taken by one of their representatives and it wasn't done at their lab and it wasn't, they didn't have their hands on it. They're taking somebody else's work. And by work, I mean just the blood sample and how it was taken, protocols, whatever. They're taking somebody else's stuff and then they're doing their, testing on it and their math on it and their whatever to give you that range, remember? But Alessi makes a very good point, of course, and says that that the Commonwealth has conceded that the testing did not occur at an accredited lab. It's in all of their reports. This is not a contested thing. Everybody knows this. But he also says, that the report specifically says it is not intended for use in court-related proceedings. So, can they still use it? It was allowed to be used last time. That can be kind of one of those things where they say that it is going to be able to be cross-examined on, but not excluded. It may be the same situation here, so we'll see. And then the last one, I think they said, was that the one that was for Richard Green's prior record? They went through that one so fast because they were like, yeah, we have no argument on that one. I think that's what that one was. The trolls started going wild because the defense expert, Richard Green, and chat, tell me if I'm wrong on this one because they went through it very fast and I was trying to make notes too, but they said the trolls started going crazy because Richard Green had a drunken disorderly charge from years ago, like at a bar in Key West or something like that. Like, oh well, I'm sorry if somebody got drunk at a bar in Key West and that must mean that that the report is wrong. Like, what? That makes no sense. It's so stupid. It's like find actual reasons to discuss this and debate this. I wish that people would focus on the actual stuff and not stuff like that. It's crazy. It's crazy. Hank got bad info from the Twitter trolls. Shocking. Yeah. I mean, well, it's like, that's the same thing. Like when Hank quoted my interview with Dr. Kinsey, he got, I'm almost positive he got that from Twitter because they, all the trolls were clipping like that one little snippet and it was out of context and it didn't show the rest of it from Dr. Kinsey's interview. And so I'm like, he didn't even give the right context of that and stuff, but he used it. It is crazy how much he relies on Twitter and TV to create his arguments. I've never seen that happen in a case like this before. I've just never seen that. That's so odd to me. He has said multiple times that he did not watch the first trial, but he's watching TV and Twitter. And that's something I've never seen before, and it's odd to me. But that's where we're at with this. I don't get it. I don't get it. So that is the quick breakdown for everything missed this morning. The spiciest part so far has been Auntie Bev and her anger toward the defense this morning. So we'll see. I just wish that it were balanced. I really, really wish that the same rules applied to both sides. And I wish that the same energy from the judge was applied to both sides. And the reason that I think it's so much more important in this case, not more important, just equally as important, but the reason that it's such a big deal in this case is because this is one of those cases where so many things don't make sense, and there's so much nonsense surrounding this one, and so many things that are wrong about the investigation and about the witnesses and about just reports and times changing and butt dials and phones being destroyed and, you know, all of these things happening. And so it's hard when there's already so much on both sides that leaves so many questions open. I feel like having, if we had a judge who could really just lay down the law in a very fair way and say, no, like, you can't do this and neither can you. And if false statements are made, thank you, babe. Thank you. It's getting thirsty.
I'm going to work.
Okay, bye. Love you too. Check, they bring me some water. Okay, so if we had a judge who would be able to step in and say, you know, like, and be like an actual, like, beacon of fairness in this trial, I think that it would be so helpful, because with all of the issues in this trial, we really need a fair trial so that all of the evidence can be presented in a fair way and all of the arguments can be presented in a fair way. And that way the jury gets the best information, and they, you know, and the defendant gets the best, you know, fair trial opportunity, and everything is done properly in the way it should be. And I am all for, you know, the jury getting all of the information that they can. And I feel like so much has happened that has made me lose some faith in how this is being handled. And I thought it was just me. So I started, you know, talking to some other attorneys and getting some other attorneys' input, and even some attorneys that are very prosecution minded. And even they are like, no, this is a, you know, this is wow, this is a problem. So it's something. It's something. Yeah, he doesn't want the car to be at Fairview. I think the car absolutely needs to be at Fairview. I think that that's part of understanding. It doesn't matter about the lighting and the snow. They're not going to see it because they want to see the lighting and the snow. They need to see, like, the whole point of it is to see in person, you know, the size of everything and the, you know, because everybody has said that, you know, goes to Fairview, how small that yard is compared to the pictures that you see. And I think that that's, you know, kind of bye, Chat Daddy. I think that's something that's kind of a no-brainer for me. So I would expect that one to be you know, for her to be allowed to go, and for, because she had said she had to, that's the part of it that I thought that she would have a problem with, is allowing Karen to go, but she doesn't have a problem with that as of now. So we'll see how that one goes. How much of the transcript from the first trial can be used by the defense to impeach testimony? All of it. So that, you know, that's one of the things going into this trial, that they have the you know, they have minutes from the grand jury testimony, they have their previous statements, they have, and now they have the previous trial transcript. But what they can't do is say, hey, remember when you told that federal grand jury this and this and this, or remember when you said in the last trial this and this and this. All they can say usually is that they had some kind of, you know, previous statement. Do you remember when you said in a previous, you know, hearing or something for this, or in a previous situation for this case, whatever. But they usually cannot, we know they can't bring up the federal investigation or the federal grand jury, and they usually are not able to say anything about a previous trial either, because then the, you know, the jury can get to imaginations running wild and, you know, thinking about why there were previous trials or what happened before or whatever. She should have quoted Paul during the interview with Christian Rex. Yeah, on having the people there for the jury to see. I think that's important too, because it does show, you know, a deliberate intention of affecting the jury. It's a deliberate action to make the jurors see things a certain way. And which, if y'all remember, I said that in the last trial. I specifically said, as soon as I saw them sitting there in the last trial that day, I specifically said, I was like, I guarantee that they were brought in during closings, because now they're allowed to be in there, because now the sequestration is over. They're allowed in there in closings. And I specifically said in the last trial, I said, I guarantee they are being brought in so that they can send the message to the jury of, you know, oh, you need to know that we don't buy what the defense is saying. Like, they're on our side. And I specifically said I thought that was the reason why. And then turns out. Plus, I don't want to have to set up two separate views. I think that's one of the biggest parts. Like, the judge is not going to want to have to set up two separate views. Susie H. gifted 5 memberships. Thank you, thank you, thank you. Thank you, thank you. Oh, Justice Obsessed said previous proceeding. Yes, thank you. Sometimes I can't get the words out, and y'all always have my back. Always have my back. Yes, it's all by design. It's all by design. Yep. That is intentionally swaying a jury, and I'm on the defense's side with this one. I think that the jury needs to be able to make their decisions based on the facts and the evidence and the opinions that are given during the trial. I don't think that they need to be making their decisions based on messages that are being sent to them from the gallery. But what do I know? What do I know? Yes, Turtle Boy does have a hearing today. At noon? Is that what they said? I think. Let's see. Lawyer EDB and Lawyer Lee have all jumped into the Karen Reed camp. These are all channels that really play things down in the middle, often through the verdict. The Commonwealth is rotten to the core. That's what I have not seen that Lawyer Lee has. So that's interesting too. Yeah, I have seen EDB and I have seen Peter, and those are two of the ones who I will sometimes, like, if there's something like a legal thing that I'm like, am I crazy about this? Like, let me see, what other, like, what attorneys' perspectives are on this. And I'll kind of like check myself. What's weird? EDB is, her and I have some of the same mannerisms. So there are some things, like, I'll go back because I do it live, of course. So I don't know how people are reacting until I can go, back later and I'll, find certain things that I'm like, I want to see what they say about this. And I'll find things, and some of my over the top mannerisms that I always think are like, oh, I should probably quit that. That's over the top. Then she doesn't too. I'm like, okay, well then now I don't feel so bad. I'm not the only one who like, it's always my hands like this and stuff. So, it's funny. Her and Peter both are, really good about being straight down the middle with a lot of stuff. So I like seeing their perspectives, and yeah, they both have kind of seen a lot of this stuff and been like this isn't balanced. This isn't how it should be. Because to me, this is not about, and I've said this all along. I have said all along, I don't know what happened that night. I have never given any opinions ever publicly about, what I think happened. And there's a specific reason for that. I have ideas, but I feel like it would be irresponsible for me to say, I think that this person did it, because having this platform, it's hard for me to say that I think one person did it. I can't give one person the benefit of, presumption of innocence, I should say, and not others. So I may have ideas, but I don't say them publicly. My job is not to figure out who did this. My job is to take a look at everything, analyze it, overanalyze it, look at it, weigh it, and see what I think about if guilt has been proven or not. And there's not a chance in heck I could see a guilty verdict on this for me personally, because there is too much reasonable doubt. So that is my stance on it. That has always been my stance on it. That will remain my stance on it unless my stance can be changed in the next trial. So far, it has not budged. I see way too much reasonable doubt. I think in order to say, that they have proven their case and that, I think that she's guilty beyond a reasonable doubt, they would have to show that there's no other reasonable explanation for anything. And it's just too much. There's too much reasonable doubt. There's too many situations in this case where things just haven't added up.
Session may be seated.
So that's where I stand.
All right, so Mr. Jackson, I'll hear you on that one motion.
Thank you, Your Honor. I appreciate it. It won't take very long. I want to formalize a motion to continue the start of the trial, which is currently set for April 1st. The reason behind the motion to continue is not because of some conflict that the defense has. We ordinarily would be ready to go. However, as the court knows, there is a significant appeal that's currently pending before the First Circuit based on Judge Saylor's opinion that was issued about a week ago. Given the complexion of what we're moving toward trial for, in other words, count 1, count 2, and count 3, we are mounting a defense based on those 3 counts. If the First Circuit, and I've been advised by our appellate counsel to bring this up, and it was something that he feels very strongly about, we all do.
Okay, Mr. Weinberg?
Mr. Weinberg, yes, okay. Martin Weinberg. If in fact the First Circuit were to agree with our appeal and were to take some action on count 1 and count 3, for instance, either dismiss it or take some other action and remand down to the trial court for additional action, that would set the trial into upheaval. If once the jury is sworn, jeopardy attaches. And once jeopardy attaches, if there were to be some action taken on count 1 and count 3, for instance, those counts were to be dismissed, we would then be compelled and impelled to move to dismiss the entirety of the trial at that point, because that's a very different defense on count 2 than it is on count 1, 2, and 3. It's a different jury that we would pick. It's a different strategy that we would employ, and jeopardy will have attached and the entire case would go away. Ergo, we believe the best practice for the court would be to continue the trial for purposes of letting the First Circuit make its determination about count 1 and count 3, and that's the reason for the motion.
All right, do you have any timeline on that?
I wish I did. I don't. I do have a generalized understanding of some of the briefing schedule, but in terms of the court making its decision, I don't. So we expect to get our brief in today, probably by the end of the day today. I believe the Commonwealth is going, or I believe that whoever it is that is appearing for the Commonwealth, or for the court, I should say, not the Commonwealth, for the court, is due to file their responsive brief, their opposition. I think it's next week. It may be as late as the 26th, I want to say. I'm going by memory, Judge. So it's Monday? Okay. Mr. Schillinger has just indicated, I appreciate that. Did I say your name correctly? Thank you. Just indicated that it's Monday. The opposition is Monday, and then the reply brief would be to you 2 days hence. So the briefing is going to be done in relatively short order. The decision, that's another question.
All right, thank you very much. Does it make sense for me to hear from Mr. Schillinger directly, or do you want to handle this, Mr. Brennan?
Thank you.
I forgot I muted myself. He's the one who's arguing for the appeals process. He's the one who's arguing that.
Good afternoon. So we do need you to say your name.
Yeah, good morning, Your Honor. Caleb Schillinger.
All right, Mr. Schillinger, I have no idea how this works. So why don't you tell us?
Sure. So as Attorney Jackson mentioned, Your Honor, Judge Saylor issued his decision denying petition for habeas relief last Thursday. The defendant is pursuing a further appeal to the First Circuit. The parties have agreed to an expedited briefing schedule in front of the First Circuit. The defendant filed her brief earlier today in the First Circuit. The respondent's brief is due Monday, the 24th, and then the defendant's reply brief is due Wednesday, the 26th. As Attorney Jackson mentioned, parties are able to control that much in terms of coming up with an expedited briefing schedule. How long it would then take for the appeal to be decided after that is unknown, and the parties don't have the ability, obviously, to dictate that. I think more broadly, Your Honor, in terms of the arguments here, certainly if it were possible to have all of this resolved before moving forward, it would be ideal to know which charges are going to go forward and which aren't. At the same time, Commonwealth is obviously strongly opposed to moving the trial. And so, while perhaps unfair to Your Honor, if there is some intermediate ground or additional information that Your Honor would be able to provide, I think that that would be helpful. We could further discuss this issue and come back tomorrow. I would note the motion for a stay that they are going to file, they have indicated, or Attorney Weinberg has indicated to me through email, will be filed with Judge Saylor, not with the First Circuit. So there's no deadline that that motion be filed today, tomorrow, or even Thursday. So this is not a decision that needs to be made immediately, Your Honor.
Okay.
And frankly, the Commonwealth would benefit from additional time to be able to discuss with the victim's family members, and to the extent perhaps the court is able to indicate whether some amount of time is feasible given the jurors' schedules that are coming in, Your Honor's schedule. That would be helpful information to inform this as well.
All right. I appreciate that. So one of the things that we would discuss at a final pretrial conference is how long this case is expected to take. So I think the Commonwealth filed or filled out the pretrial conference report a few weeks ago and said 20 trial days, 40. How many trial days do you remember you said, Mr. Brennan? Or what do you think your Commonwealth's case will be?
I don't remember what I put specifically, but I think if we have
You put
full
20
trial
days.
days,
Yes.
5 days a week, I expect less than a month. I'm shooting for 3.5 weeks.
Okay. Mr. Jackson?
Your Honor,
24, I'm sorry.
our defense obviously is somewhat dependent upon the Commonwealth's presentation, but
Right.
my best estimate would probably be a week and a half, 2 weeks of full trial days for the defense, if I had to sort of throw a dart.
Okay. All right. The big question is jury impanelment. Again, I alluded to all the recent publicity that I think is going to be very problematic in getting a jury. So I'll let both sides talk. That makes sense to me. Months and months ago, we got the jury commissioner's office on this to get us the amount of jurors we need starting April 1st. That process will take additional months in order to, if we change the date. So that's very problematic. So I'll hear you all tomorrow on this then.
May we address the court at sidebar on one issue before you leave the bench?
Sure.
So that is going to be a difficult situation to have the appeal pending while they're starting this trial. It just needs to be over. But so much has happened. Feels like this is just never going to end. No, I think that they're about to end for the day and then they'll be back tomorrow. I'll get the stream set up for tomorrow as soon as we finish here today. Toby, did you go back and see when Karen appeared on Glaire's stream yesterday? No, I did not. I popped into that stream for a minute when we were on the way back from the Keys. Chat Daddy was driving, so I was playing on my phone. And I did see it for a minute, but I have not had a chance to go back and watch it. I've got a lot of stuff I've got to catch up on, actually. I didn't work at all. Well, that's not true. I did work for a couple hours when we were in Miami because I had to, but for the most part, I didn't do much this weekend. I was trying to stay away from it as much as possible.
All right. So we'll see everybody back here tomorrow, but Thursday morning at 9 o'clock. That'll give you time, Mr. Schillinger, to speak with maybe Mr. Weinberg or counsel.
It will. Thank you.
Okay. So we'll see you Thursday. All right. Thank you, everybody.
All rise for the court, please.
Okay, so we're doing Thursday instead of tomorrow. Good to know. Give them more time to work some of the stuff out, so hopefully we can get through it. Oh, isn't that John's girlfriend from a million years ago that keeps showing up on everything? Right there.
Goodbye.
Yeah, not tomorrow. I guess they changed it to Thursday so that,
I got it. Get too close, I don't think you can say.
I will, I know. I know. Just trying to eavesdrop. I guess they changed it to Thursday so that they can have time to try to get some of the stuff worked out and get some of the stuff figured out before they come back. So we'll see. We actually ended a lot earlier today than I was anticipating, which is a good thing because it gives me time to get caught up on some stuff. And we will be back on Thursday, so I can get our stream set up for Thursday in the meantime. I'll get it set up in just a little while, and then we'll be back Thursday and be live. Isn't something else going on Thursday? Where's my calendar? Where's my handy dandy calendar? I feel like Thursday is something else. Or maybe, what is Thursday? So what this means is that the podcast episode will not be out until Friday, possibly Saturday, because I'm going to want to fit everything from Thursday into there. So depending on how long they go Thursday, the episode may not be out till Friday. I've been doing them on Fridays lately because I'm trying to get all the stuff that's happening throughout the week in there. And then on Fridays, we've been getting bombarded with motions. We have been getting bombarded with a ton of motions. So I'm trying to get them out on Friday, and then starting over Friday on my new episodes with 742 new motions that were filed. But that's okay. So we're getting ready for the new trial. This is expected. We knew that it was going to happen when we get closer, so it's fine. Everything's fine. We're going to be fine. All will be fine. All will be fine. Please let us know your opinion of the ID series Body Found in the Snow. I will. My main opinion, though, is that, well, first of all, it's interesting how many of us got cut from that. So that makes me interested to see what direction they're going with it. Because there are so many people who are actually close to Karen and stuff who got cut from there. So I'm curious to see what all they say. But also, is it 3 parts, right? Are all 3 parts out now, or just the first episode? I saw somebody earlier saying it was on HBO now. Because isn't it 3 nights in a row? I haven't paid that much attention. I should. They interviewed me for it. They interviewed the Roccos for it. They interviewed some people who worked with Karen before for it. So they interviewed a lot of us, and then they didn't use, they sent us all emails telling us that they're not going to use our stuff in there. So it's but somebody said they had coffin daffer. Why? As much stuff as she gets wrong about everything, I would just think if you want credibility. But whatever. Oh, was that no, that was not the big project. That was just something I never even mentioned that because it was just something that, it was just an interview. That was not, no, that's not my big project. Not at all. That was just something I interviewed for and then kind of forgot about it. Why would you want somebody who has no credibility on there? It's a bad idea this is airing now. I think that it is, to me, and this is just me, I think that I don't think it's a good idea to be doing a lot of interviews and stuff right now for the defense. I think that, or not for Karen anyway, because like even you hear Hank Brennan, you know, every single thing she says, he will take it and, you know, use it in this trial against her. And I think I've always said I think it's a bad idea for defendants to take the stand unless it's, you know, there's very few situations where I think it's a good idea. Like Travis Rudolph was a perfect example. His was a good take the stand. The jury needed to be able to hear from him. I thought that was a good one. Most others, I can't think of another one where I'm like, yeah, it was a good idea for them to take a stand. I can't even think of one right now. Chat may be able to. I can't even think of one right now. And it's kind of the same with interviews. I think that it's a bad idea because things can get taken out of context, things can get twisted, things can, you know, a lot of times when we're talking, and I do it here all the time, like I'll say things, you know, like just random thoughts that will come into my head and people will clip those and be like, Brandy said this, you know, it is crazy. People will take things and use it against you, which is fine if like, okay, I'm just a podcaster. So if you clip something and spread it all over, you know, social media, whatever, do your best. Like I could care less. Like, you know, the people who matter, you know, are like, listen to me and know my thoughts and know that, you know, whatever. So I don't care. When you're on trial for murder, it's a totally different situation because as much as we say you're supposed to have the presumption of innocence, that is a hard concept for some people to go into cases having. We are ingrained a lot of times to automatically think that if somebody's on trial, then it's like we're rooting for justice, right? We're rooting for, you know, the cops to have gotten the bad guy, and you know, we're about to watch this family get justice. And that's not always the situation when it comes to these trials, because there is a lot of political pressure. A lot of times there is a lot of pressure on, you know, police to get an arrest, you know, like the public is mad and they want justice, you know, whatever so you have to arrest somebody. So I feel like a lot of times they do get the wrong person. So when we go into the trial thinking, you know, even if it's subconsciously thinking like, okay, well, this person's on trial, you know, there's at least got to be some evidence against them. It's hard sometimes, I think, for people to differentiate the fact that, yes, they may be on trial, but that doesn't necessarily mean that, you know, that they got the right person. And going into things with the presumption of innocence can be really hard. So when you do interviews and you do things like that, a lot of times those things can be twisted and clipped out of context and used. And I'm saying this, I don't know that, I'm not saying that that's what they've done with her. I have not seen it. I told y'all I have not watched it, have not seen it. But I'm just saying in general, this is a very generalized statement. People can use things against you, and it's just a bad idea to do interviews and stuff. That's my thought on it. But I also understand, you know, she is having to fight this again and going through yet another trial, and that the cost is expensive, and raising awareness about what has happened has helped, you know, her be able to raise money, you know, for the experts and for the defense and for all the things that she needs money for. So I mean, I get that side of it too. It's just very risky to do any kind of, you know, any kind of interviews. So, especially with Brennan, who doesn't watch the trial but watches the old interviews. So, whatever. That's just my thoughts on it. That's just my thoughts on it. So Matt says they never intended to investigate starting from 2:27 a.m. that morning. Lucky would have been blamed if not for Karen looking for John. Yeah, I mean, if her taillight wasn't cracked, I think that that's one of the big things. And I know that the defense has their, see, part of the whole taillight crack thing, like, I don't know if and I said this before, I don't know if the taillight was cracked when she backed into John's car. I don't know if the taillight was cracked if, you know, he did throw a glass at the car, like if, you know, he was mad at her or whatever. Like, I don't know if, you know, a seagull swoop, okay, maybe not a seagull, Florida shit, but I don't know how it broke. But what I do know is that they have not given me reason to believe that it had to have been by her hitting John O'Keefe at 34 Fairview, especially because the pictures and stuff that they show, it doesn't look the way that it does in those pictures that were from February 1st. It doesn't look like that to me. That is a completely destroyed taillight that's missing most of it. And all the pictures I've seen, it is missing parts, but it looks different to me. It does not look the same. And, you know, that's the way I see it. I don't think that they've proven anything beyond a reasonable doubt. And that's where I stand. I don't understand how you can have all of this Sallyport stuff missing and that they could have had it for so long and have it missing. And then the videos that they do have, there's so many questions on them. And how were no pictures taken in the Sallyport of it? They took a picture of the front of the car. We saw that. We didn't see the picture, but we saw them on camera taking a picture. So where's that picture? And did they take one of the back too? Why do we not see that? It's just too much. It doesn't make sense. It's too much. And I think that's a problem. So that's where I stand on it. Did you see the video of the guy who was breaking those taillights on YouTube that she show how thick it is and how hard it is to break? Yes, I did see that. And I actually mentioned it. That's the be in trouble thing. I did see that, and I actually mentioned it on my last episode of the podcast because I was like, that was really interesting. And how he was showing how it lights up once it's broken and stuff. So I saw that. I did see that, and I thought that was really interesting. So very, very interesting. Very shady stuff. Very shady stuff. It'll be very... Oh, I'm interested to see if they postpone this trial. I don't know that they will over the appeal, but with, you know, it would make sense to, but, you know, Bev is saying like it's going to be hard to find a jury, so she, you know, is talking about not wanting to. So it'll be interesting to see what they do there. I have so much of my life right now planned around this trial. So that will be interesting to see what they do. Because as of right now, it is scheduled to start jury selection 2 weeks from today. So we'll see. Oh, he did another video on the taillight. I have not seen the second one. I only saw the first one that some of y'all sent to me. So I have not seen it. I'll have to go check it out. All right. Well, we're going to wrap it up. I would give y'all a summary, but I already did a summary while they were at side break, so we don't need to do another one. I will get the stream set up for Thursday. We will be live Thursday, and see if they're able to come to any conclusions about any of this stuff. And I'll go ahead and start working on the podcast episode so that I can at least have everything done up to that point. So then hopefully we can get Thursday included, and then I'm hoping to have the episode released on Friday. So we'll see. We'll see how it goes. If not Friday, then we'll have it out Saturday. Crazy stuff happening. This case just gets wilder and wilder. So, all right, y'all. I appreciate all of y'all so much. Let's see who's live that I can. Let's go raid somebody. I want to send some love and support over to some other folks. Let's see who we can crash their party. Crash their party. edit. Oh, I just realized I still have the wrong thing pinned. It's okay. I'm sorry. All right, so it looks like Recovery Addict is live. I'm going to send y'all over to him. He's doing a New Hampshire versus Jason Levesque, maybe. I probably said it wrong. Snowstorm shooting trial. And I know y'all love a snowstorm, so I'm going to send y'all over there. Thank you to everybody for all of the, for coming, first of all, for hanging out, for showing up. And also, all of our memberversaries that were shared today. I love those. I love it when we get to see the memberversaries. So thank you for sharing those. And then thank you for super chats and gifted memberships. I appreciate those too. I will see y'all. I'll get the stream set up in just a little while, and I will see y'all bright and early on Thursday. I love you all.
I gotta go. I can't stick around here forever.
Everybody was wonderful. Everybody behaved. Everybody's always so nice to me.
Just love your channel. And
Goodbye, good people. Now, how the heck do I get out of here?